Good morning, everyone, and welcome to the first day of the resumed hearing sessions part of the examination of the Bayborough and Mid Suffolk Joint Local Plan. If you can't hear me, please can you make sure you let the programme officer know as soon as possible. My name is Alison Partington, and I am one of the two inspectors appointed by the Secretary of State to conduct this examination and to report to the Council in due course. Before we make a start to today's discussion, there are a number of housekeeping points that I need to go through. Firstly, to avoid disruptions to the proceedings, can I ask everyone to ensure that their mobile phones and laptops are turned to silent or put in do not disturb mode whilst the hearings are in session? As you are aware, the sessions are now all taking place virtually using Microsoft Teams. Everyone should now have received guidance on attending the event from the programme officer, and that guidance is also available on the examination website. I won't repeat all of it now, but there are a number of key points that I must make people aware of. Firstly, you need to know that the proceedings are being live streamed to YouTube in order for the general public to be able to observe them. Anyone who makes their own recording of the hearing sessions or any part of them should make sure that they comply with the law in terms of any distributions they make of the recording. Today's session is covering matter 5, which deals with local housing policies. The format of the session is a structured discussion which I'm going to lead. Whilst the discussion will be based upon the matters and questions which I have identified for this topic, there are some issues which I need no further information on beyond that which I've already received in writing, and on which there will therefore be little or no discussion. On other matters, I have a number of supplementary questions based on the contents of the statements I have received. All previously submitted written evidence is to be taken as read and need not be repeated at length. I'm not expecting that any additional or new material will be tabled at the hearings, as the aim is for everything to have been made available to everyone up front so that we can have a useful discussion. If you wish to refer to me to documents within the examination library, please can you make sure you give me the reference number as well as the name of the document. When you're not speaking, can you please make sure that your microphone is on mute? Given the number of participants today, whilst the discussion is ongoing, you may wish to switch your camera off when not speaking, although it would be helpful to me if at least the council witnesses would keep their cameras on. If you would like to contribute to the discussion, please use the raised hand function. When I invite you to speak, please remember to unmute your microphone and put your camera on if you have switched it off, remembering to mute it afterwards and take down your raised hand. I will invite participants to speak in an order which I consider is best to assist me, so please be patient if I don't come to you immediately. When I give you the opportunity to speak, please can you say all that you need to say. Please make your contributions brief, focused and relevant to the question I ask. And there is no need to repeat what other people have already said. And can I remind you that there is to be no use of the screen sharing function. I would ask everyone to be patient with each other, as some people may be less used to using technology and so may find getting to grips with it more difficult than others. Each session will be around 90 minutes in length. So this morning the sessions will run from 9:30 to around 11, and then from 11:30 to around 1. And the afternoon session will be from 2 to around 3:30. Now I'd like to ask each of the participants to introduce themselves. Firstly, for the council.
Good morning, Madam. My name is Michael Bedford, Queen's Counsel. I'm instructed by the two councils to assist them with legal representation during the course of the local plan examination. and today it's likely that in addition to me, you will hear from Mr. Robert Hobbs, who is the Corporate Manager at Strategic Planning for the two councils, together with Mrs. Jennifer Candler, who is one of the Senior Strategy Planners.
Thank you very much. Now I'm going to take the list of participants that I've been given in alphabetical order. So could I ask who the representative for Amber REI is?
Good morning, Mark. That's myself, Ben Cook from Pegasus Group.
Thank you very much. And then for Artisan Planning?
Good morning, it's me, Max Short. I've also got my colleague Leslie Short here as well.
Thank you very much. Ballymore, Mr. and Mrs. Price? Are they not here today? Right.
Sorry, I am here. I was struggling to unmute myself.
Right.
It's to change from speaking whilst on mute. Apologies for that. Yes, it's Nikki Parsons from Pegasus Group.
Super, thank you very much, Nikki. Chiltern Parish Council.
Yes, I'm here. Valerie Hart on behalf of Chiltern Parish Council.
And you're also here in a personal capacity, are you, Lady Hart?
Yes, I am.
Right. So can you make sure when you contribute, you tell me whether you're doing so on behalf of the parish council or on behalf of yourself as an individual? That'd be helpful.
Yes, I will. Our views are pretty much identical.
Right,
so
that's
there shouldn't be much differentiation.
Thank you.
Thank you.
Crest Nicholson.
Good morning, Madam. Derek Stebbing from Stratton Parker, representing Crest Nicholson, and also John and David Diper, who are the landowners. Thank you.
Thank you very much. From Gladman.
Good morning, Ma'am. My name's Stuart Carville. Apologies, you may have my colleague down as attending, who's Josh Plant, but it's me today, Stuart Carville, on behalf of Gladman. Thank you.
Thank you very much. Harris Strategic.
Richard, is that yourself, Richard Brown?
Sorry, Ma'am. I'm actually, yes, I'm appearing on behalf of Lambridge Property, but it's the same. Harris Strategic are within the group. My apologies, Ma'am.
Right, thank you very much. For the HBF.
Good morning, Ma'am. Mark Berrant from the Home Builders Federation.
Thank you very much. So Lambridge, you've said, is the same as Harris Strategic. Yes. Lady Hart, and you're here as well as with Chiltern Parish Council. Mid Suffolk Green Party.
Good morning, Madam Chair. Andrew Stringer, representing Mid Suffolk Green Party.
Thank you very much. Persimmon Homes.
Good morning, Madam. Anas Makda from Pegasus Group. Thank you.
Oh, right. Yes, thank you. Yeah. From Pigeon.
Good morning, Mum. Yes, Sophie Payne from Turley, and I'm also joined by Rob Snowling from Pigeon as well.
Thank you very much. Sproughton Parish Council.
Yeah, good morning, Madam Chair. It's Helen Davis from Sproughton Parish Council.
Thank you very much. Suffolk County Council.
Good morning, I'm Cameron Clough from Suffolk County Council.
Thank you. T. Richardson.
Good morning, Dan Hewitt from Wilson Rate.
Thank you very much. And Taylor Wimpey.
Good morning, Mum. Yeah, that's myself, Bethan Haig from Boyer. Thank you.
Thank you very much. I think that's everyone I've got down. Is there anyone else who hasn't introduced themselves yet? Right. Having done that, unless there's any housekeeping points that anyone from the council or from the programme officer need to raise, or has anyone got any questions on the procedural aspect of the session today? Mr. Bedford.
Thank you, Madam. Madam, there is one minor housekeeping matter that I should just mention at the outset. These hearings obviously are the resumed hearings from earlier this summer, and what is Examination Library Document H15 is the notice of the resumed hearings, and 6 weeks notice was given. There's no doubt that everybody's been given notice, but actually if you look at H15, there was an unfortunate typo in relation to the document, in that it refers to today, the 22nd of September 2021, but it also refers to Monday. So it says Monday, the 22nd of September. So that's it's an unfortunate typo. I don't consider that there are any implications of that, in that the requirement in Regulation 24 is to provide a notice 6 weeks in advance, and that notice should specify the date and the time of the hearing. That has been done. Obviously, if there were somebody who had read it and thought that today was actually happening on Monday, they might have attempted to log in on Monday and they would have been unsuccessful, but they would have then not suffered any prejudice, because they would have then realised that obviously today is the day it's happening. Yeah. And it's also quite clear from the participants that everybody realised that today was the day rather than Monday. So I just mention it for completeness, but I don't think there are any consequences, and therefore there's no action that we would suggest that anybody needs to take in relation to that.
Yes, thank you, Mr. Bedford, for highlighting that. And as you say, people are all here, and you've given us 6 weeks' notice. So I would concur with your view that it hasn't prejudiced anyone.
Thank you.
Right, then we can now proceed with the discussion for today, which we'll start with by looking at policy LP01, which is on windfall developments. Now, I'm aware that the council have suggested a main modification to LP01 in the last couple of weeks, and I'm aware that not everyone may have picked that up. So I wondered if the council could start by just briefly explaining what that main modification is about, and the reason for the suggested changes that they've made. I don't know if it's that Mr. Hobbs or...
Well, Madam, if I just briefly start, and then I think probably Mr. Hobbs to deal with the detail. For those who want to follow the matter, it was in document H30 in the examination library, and Madam, as you will recall, and those who observed the hearing on the 21st of July will be aware, the session there with Mr. Rivet was to explore the council's approach to its spatial hierarchy and spatial distribution, and amongst the actions that were then tasked to the council arising from that was for the council to reflect on the terms of policies SB03, SB04 and LP01 with a view to achieving better sort of clarity in the way that they were formulated. That task was undertaken, which then led to the submission of the documents concerned, including document H30 in August, and they were then added to the examination library website. And the suggested changes to those three policies, and since work as a suite, so you should read them, as it were, as a whole. And one of the changes was in relation to policy LP01, and it was to propose the removal of the concept of dwelling clusters, and then therefore to limit the policy so that it's applicable to hamlets. And then reading that suite of policies as a whole, the way that it works is that the hamlets which are defined in policy SPO3 in tables 2 and 3, one table per district. Those hamlets have settlement boundaries, and within those settlement boundaries, whilst the principle of development is acceptable, that is then subject to the specific criteria in policy LP01, which sets out more detailed criteria as would be appropriate for the local policy, as opposed to the more strategic policy SPO3. So that's the position in a summary, and then perhaps if I turn to Mr. Hobbs to comment on the rationale and why, in the light of the discussion that took place in July, the Council is suggesting those changes. And perhaps I should just formally make the point so that those concerned are all clear about it. At the moment, the formal position is that the document H30 has been provided into the examination as a suggestion by the Council of proposed main modifications. It is not, however, a main modification at the moment, because, as you, Madam, will know, main modifications are matters which are vested in you and Mr. Rivet as the examining inspectors. If those suggested changes find favour with you in the light of your deliberations, obviously they will then in due course have to be promoted as a main modification, and I'm expecting that you are likely to require a period of consultation on the actual wording of specific main modifications, and you will want to take those consultation responses into account before you make a final decision as to whether they should be main modifications. So I'm saying that to you because you know that already, but for anybody who's less familiar with the process, to understand there will be an opportunity for formal representations to be made on proposed main modifications. So as it were, nobody's disadvantaged by the fact that the Council has provided this at this stage to the inspectors for their consideration. So then I say, going back to Mr. Hobbs, if Mr. Hobbs then perhaps just wants to provide some comments on the rationale for why we have made those suggested changes.
Okay, thank you, Madam. So effectively, the policies, enabling policies, sort of giving greater certainty, recognising sort of lesser sustainability of settlements, and on the back of the discussion we had for the matter 4, giving that greater clarity about what we mean by a hamlet as well, removing the reference to the dwelling cluster. Many of the hamlet settlements previously wouldn't have had a settlement boundary either, so this is rationale for introducing that, and then in accordance with, as Mr. Bedford's referred to, the discussion we had around the strategic policies at the time.
Yes, thank you. Can I just clarify a couple of things with what the wording that has been suggested by yourself in this suggested modification, because it in the suggested text that you've provided in H13 in your schedule of text of suggested changes, the wording that is in there is slightly different to the policy that's actually in the document that I've got. So, for example, in the policy in the plan, it says a defined hamlet, where the word defined is missing in the suggested text. It's not crossed out, it's as being removed, but it just doesn't appear. And I wanted just to clarify whether that was just a typo. And similarly, at the end of that paragraph, before it goes into the criteria, the word applied, which appears in the plan itself, is missing, and it isn't a word that's been crossed out. And I just wondered whether that what the reasoning for that was, whether it was just an error in there, or particularly in terms of the defined hamlet, and using just the word hamlet, because I want to understand exactly what you mean by a hamlet. And Mr. Bedford, you've suggested it's the hamlets that are listed in the settlement hierarchy, but obviously I just want to clarify what that means, and whether the different wording there.
Yeah. Oh, apologies, madam, for the error. Yes, the word defined should be crossed out, and then the word applied reintroduced.
Right, so you're not saying a defined hamlet anymore, you're just saying a hamlet.
Yeah, in accordance with what's in the policy SPO3.
Right. So is it clear that, will people be clear that with that, if it just says hamlet, will they know that that means the hamlet's listed in SPO3? Or will, because how is hamlet defined if it's not the hamlets that are in the settlement hierarchy? I want to understand.
Well, I think, madam, in a sense, there are two ways of dealing with that point. You're right that the original policy used the expression defined hamlet, but there was no precise definition in the plan of what that term meant. So it didn't actually say what was a defined hamlet, and that wasn't a phrase that was set out in the glossary of the plan. So there was arguably an ambiguity there, although by implication, it was apparent that when you read that together with SPO3, which set out the hamlet villages, that they were the defined hamlets. I think we took the view that it was actually clearer just to use the word hamlet, simply because the only hamlets that there are in the plan are the hamlets which are the hamlet villages which are set out in the tables that support SPO3, and they are therefore the locations which have settlement boundaries, and they sit at the bottom tier of the settlement hierarchy. I say whether you reintroduce the word defined and then add as it were, a footnote to cross-refer back to SPO3, I think we're probably neutral on that. If it aids clarity, then obviously we'd be perfectly content to do that. I think we took the view that it was an unnecessary word, because the only hamlets that the plan deals with are the ones in SPO3. But if I say there's any lack of clarity in that, I think we'd be perfectly, I say, neutral or relaxed about achieving better clarity. And as to the word applied, again, I think that was probably just an editorial change. We thought it was an unnecessary word in the context, but I say we can deal with that, and if it's helpful to reinstate it, we can reinstate it.
Thank you for that clarification. Just another couple of issues before I ask for if anyone's got any things they want to raise about the suggested modification. I'm aware in paragraph 1302 you refer to paragraph 78 of the MPPF. Obviously that is now paragraph 79 due to the changes. I'm just really flagging up that probably you need to go through the entire plan and just pick up those paragraph changes as they'll be needed, as probably additional modifications rather than main modifications, simply as they're just correcting that. But that's something that obviously not just in this policy, but right through the plan, that you'll need to pick up those paragraph numbers changing. So can I ask if it, in terms of this suggested change to this policy that the council have put forward, are there any people who want to raise any questions about this, or any any comments on what the council is suggesting here? Does it meet some of the objections that have been made against the policy? Does anyone want to say anything about it? Is Mr. Short?
Hi. Yes, there's just one point I'd like to mention, is that with paragraph 1303, it does refer to dispersed communities and clusters of houses. I don't know if that also needs to be picked up in the deletion of clusters from the policy. And secondly, I do think that if we did refer to it as defined clusters, or there was some cross-reference, it perhaps would make it much clearer in terms of what hamlets rather were being covered by this policy in particular.
Mm. Yes, Lady Hart.
I'm all in favour of clarity, and as the whole purpose of the local plan is to enable those who are not specialists at any particular field to find their way round it, I would endorse, Madam, your suggestion that there is a reference to policy SP03, because otherwise it's rather like a Latin textbook. You're looking for see attempt, that tells you to look at endeavour, and then it then tells you to see try. I'm all in favour of it making it as clear as possible. So I think there should be a reference to SP03, and then the reader can easily be directed to the appropriate policy. Thank you.
Thank you. Right, I think generally I agree that with the suggested wording. I think the wording is helpful. I think, but I do think some cross-referencing to what is meant by a hamlet, I think would be helpful, and would be make it very clear that we are referring to those hamlets that are listed in table 2 and 3. So I think if the council could look at that and come back with some alternative wording to tweak that, to get that, would be helpful.
Okay. Adam, we'd be happy to do that.
Thank you. And as Mr. Short said, I think you may need to look at paragraph 1303 as well, and just look at the wording in there and address that. I think people, I don't think you particularly noted, but you are suggesting the removal of paragraph 1304, I think, as well, which I would agree with. I don't think it added anything to the policy, so just so that people are aware that that's been suggested, that it's being removed. Now, having addressed that, I think a number of representatives have suggested that the wording should refer to windfall developments that are adjacent or well related to a hamlet, I wondered if the council could give me their thoughts on that and whether that is appropriate.
Okay, Madam, if I briefly start and then Mr. Hobbs on the matters of detail and the council's thinking. Madam, this is a matter where the council is very much in the interests of clarity, and we take the view that using the tool of settlement boundaries provides clarity, and that development inside a settlement boundary has a different, as it were, policy regime to development outside of a settlement boundary. And that clarity is confused if you then blur, as it were, a settlement boundary by having a policy which is then permissive of development outside of a settlement boundary, provided it's adjacent or any other similar word, because you then have uncertainty about where that permissive regime actually applies to in terms of parcels of land, and what does or what do you have to do in terms of achieving adjacency? How far does an individual site extend in order to be still an adjacent site? And I say it opens up a great deal of wider questions, which we don't think aids the clarity of the plan, and therefore we're not in favour of introducing such a word. And so that's our kind of overall position then. Mr. Hobbs, perhaps on the thinking and why we think it's unnecessary given the provision that is made by the plan.
Thank you. As Mr. Bedford has alluded to, that settlement boundaries are there to provide clarity and certainty, and any development, obviously not in the settlement boundary, would be in the open countryside. Also, the approach we've taken to defining or to drawing settlement boundaries around hamlets is to provide the opportunity for some planned growth in these hamlets, and we set that out in the table in SPO4 around spatial distribution. And interestingly, as we've alluded to in our document H31 on spatial distribution statement that we submitted on 10th of September, we've actually got more development permitted in hamlets than we've identified in that table. So I think we've created the conditions that are necessary to enable hamlets to have some growth, and therefore we do not feel it's necessary to have anything further than that.
Thank you. Is there anything anyone would like to say in response to that council's position on that? Mr. Hewitt?
Yes, hi. I suppose my comments that I've made in writing so far have been to question this policy, as I feel it is very restrictive, and I see it in other local authorities where they suggest that they're trying to encourage rural housing to come forward, but actually the wording of the policies are either incredibly restrictive or fairly vague, and they enable a lot of wriggle room there. So what we've got here is policy that is only looking to allow infilling, so that would be presumably within the built form of the settlement. It's then further restricting that possible development to just a single dwelling or a pair of semi-detached dwellings. So that the point about should the words adjacent or were related be included in the policy, and the concern just mentioned there by Mr. Bedford, saying that how far does the definition of adjacent extend outside of a settlement? If we're only limiting what's allowed to a single dwelling or a pair of semi-detached dwellings, then you're already having quite a limited distance from the settlement where development can come forward. So I've seen this elsewhere in East Suffolk recently with their policy, which again looks like it's opening the door, trying to encourage some housing to come forward in rural communities. But what we're doing here again is closing that door by restricting it to just defined hamlets to begin with, then to just within that built form of the hamlet. Then it's just a single infill site, and it's just a single house or pair of semi-detached dwellings. So it seems to me there isn't much flexibility here, and there's going to be a lot of sites that potentially could be suitable for development, or for more development than just a single dwelling or two semis. But actually, we're going to be seeing some negative responses from officers when we do have those pre-application discussions. They won't quite meet all the criteria, or there'll be some concern that it's going to have a negative impact on development encroaching into the countryside. That's always the classic one that seems to come back, and immediately your applicant is in a quite risky position there. And the decision would be, it's likely that officers will find a reason to refuse this, and will be at appeal. So that's the basis of my representations to date, and that's, I suppose, the concern I have for this policy. I don't know if anyone has any further comments on that, or would also echo my concerns.
Mrs. Payne?
Thank you. Yes, I share those views that Mr. Hewitt's just raised, and I think I would go on further to say, in response to what the council has said, there is obviously the rest of the policy as it's been drafted is there to afford good protection to the character of the countryside as well. So by simply adding or looking to reword to suggest that sites adjacent to existing settlement boundaries of hamlets be included, that wouldn't conflict with what the policy is seeking to achieve here. And also, I would suggest, as set out in our representations as well, is that there may be the ability to include here about reference to self-build and custom-build plots in these types of locations adjacent to settlement boundaries as well. And this will be something that I pick up in policy LP 11 later on this afternoon, I should think. But it's very much the case that in our experience is that those wishing to build their own properties do want to stay in existing communities. They do tend to look at edge of settlement locations, and again, it would be useful to have some reference to that within LPO1 as well. Thank you.
Thank you. Is there anything the council would like to come back on what others have said?
The answer is yes. I think Mr. Hobbs is going to respond.
I mean, the policy intent is to adopt a plan-led approach to enable plan-led development within these settlements, which have lesser sustainability in the settlement hierarchy. We've tried to adopt a proportionate approach to this.
Thank you. I mean, turning on to some of the things that Mr. Hewitt picked up on in terms of the in clause C about being infill. I mean, infill isn't defined anywhere. What does the council? What do you intend? Is it infill? I mean, there is a kind of a relatively standard definition of infill about it being in between, in a built-up frontage and between other houses. Is that what you're intending here, or would sites at the end of a row of houses be allowed? I mean, like what is meant by infill?
I mean, what we're intending is, generally within the settlement boundary, but within the built form, which is why we've alluded to a detached house or a pair of semi-detached houses.
So, but I mean, like what? I mean, like how how does that relate? I mean, I say within the built form, if it's at the end of a row of houses, is that within the built form, or is that at the end of the built form? I mean, like, or is it just if it was in the settlement boundary, that would be all right? I'm just trying to understand what would be allowed and
I'm just going to bring in my colleague, Jennifer Candler.
Thank you.
Thank you, ma'am. The boundaries around our settlement, our hamlet, tend to be quite tight. So in principle, we had looked at it being the general term of infill, so within the built form, because what we may have is some sort of end of the row, if you like, housing where there's very large gardens and so on. We're looking at stuff being integrated into the existing built form of the hamlets in the first instance.
But I mean, you've just said that the settlement boundaries are quite tight around the hamlets, but earlier, I don't think was it Mr. Bedford or Mr. Hobbs said that they've been drawn to enable some development to take place. Is it as if they're not that tight? Can I just get clarity on that?
They would enable development within the built form in the hamlets. Again, it's this discussion around the edge of the hamlet or within the settlement and balancing that with protecting the countryside overall. So there has been, and as Mr. Hobbs referred to, we have actually had a lot of permissions granted in hamlets already through this process. But it would be within the built form of the hamlets it would be looking at in the general definition of infill that's normally accepted.
Mr. Hewitt, would you?
Yes, just to come back on that, I suppose if this is a hamlet, the boundaries, built form is fairly tightly defined. There may well be gaps within that built up area. What I often see is the council will respond to say, no, actually that gap is too large for what's being proposed. It will result in an inefficient use of land, low density housing. We wouldn't support that. But what this policy does is actually restrict you to just one house or one pair of semis. So there's the argument that could be made by the council that no, that site within the settlement is actually too large to meet this criteria. I suppose that's my concern again, is that it's very inflexible and there's plenty of wriggle room there for somebody to use the criteria there to look to refuse a planning application for infill development.
So what would you suggest would be, have you got some kind of wording that you think would be better?
Well, I do. I think if we're generally trying to encourage some low level of housing in rural areas in these communities, we've now defined them as just hamlets. It needs to include the wording adjacent or well related. Otherwise, you're saying you're allowed quite a few permissions already, but actual fact, what we might be doing here is shutting down that ability to get a consent. I'd also suggest that Part C should either be omitted or reworded. I've suggested the following. The scale of development is to be small scale as appropriate to the size of the site and its location in order to achieve an efficient use of land.
Thank you, Mr. Hewitt.
Okay.
I mean, in terms of the kind of like, I mean, you say a single dwelling or a pair of semis. Can you council explain? I mean, why is a pair of semis acceptable, but two detached houses wouldn't be? Can I have some understanding of that?
Yeah, it's just used as a guide. I mean, a single dwelling could be the same size or larger than two semis, in our experience. But going back to the earlier point, it's really about the policy trying to be proportionate.
So I mean, although you say it's meant to be a guide, the way it's phrased, doesn't come across as a guide, does it? It comes across as kind of like it's got to be a single dwelling or a pair of semis, and that's it. so that doesn't kind of say that's just, you know, an example. It's kind of quite categorical, doesn't it? I mean, what do you think of the kind of wording that Mr. Hewitt suggested in terms of just small scale development? That I mean, have you any thoughts on that?
I think. Sorry.
So my only point was just again come back to the definition of what is small scale and how is that proportionate. But sorry.
Yes, well, I mean that's precisely the point, that one person's small scale is another person's large scale, and once you start moving away from the one dwelling or effectively a pair of semi-detached dwellings, which still amounts to one building in, as it were, context of the scale of development, you then, I say, are moving into a much more uncertain picture. And somebody might say 5 dwellings is small scale. Somebody might say anything less than 10 dwellings is small scale. We wouldn't agree with that, but we think that you'd be introducing substantial ambiguity and a lack of clarity in the policy. I say the intention is to effectively allow in these smallest settlements in the hierarchy some growth, but it will be limited growth. And we think that a sensible benchmark of what is limited growth is to suggest it will be a single dwelling or a pair of semi-detached dwellings, i.e. still a single building, because that gives you a good yardstick to measure the scale of infill development. And I say Mr. Hewitt did repeat his request for you to consider adjacent, but again that it simply adds confusion and a lack of clarity to the policy. It's effectively leaving a fuzzy edge to the settlement boundaries, whereas the settlement boundaries have been identified with care to reflect where there may or may not be scope for infill development.
Thank you. Well, that's given me plenty to consider. Lady Hart, yes, what would you like to come in here?
I'd just like to say that I'd support the council on not having adjacent. Chiltern Parish Council has experienced, I accept it's not under this plan, but under the existing terms, planning officers are quite generous to developers about allowing development. We've had housing which the Parish Council has opposed, and heritage bodies have opposed, but are being allowed by delegated decision by council officers in gardens and in the countryside. So I would certainly support having a restrictive and clear policy and not blurring the edges. Thank you.
Thank you. Is there anything anyone else wants to say, particularly about the kind of the issues of like within and adjacent and the scale of development? I think I want to go away and think about that and consider that further. But is there anything else anyone wants to say now? The only other question I've got about Mr. Short, you've got your hand up.
Yes, just a small point. I'm just trying to understand that in the instances where you have a site within the hamlet's defined settlement boundary, what is the difference in impact between, say, a site which is capable of affording 2 semi-detached bungalows, typically measuring about an 18-metre frontage, and the substitute or alternative development, which may be designed to encourage the first-time buyer or lower end of the market, with a terrace of 3? typically the profile of a dwelling of that scale, a 2-bedroom terraced house, is 6 meters. So within the same overall built form definition of 18 meters, you could either have 2 semi-detached bungalows or 3 2-bedroom terraced houses. What's the problem with a terrace of 3 houses in such locations? Thank you.
Would the council like to say anything about that?
I suppose it comes back to, again, clarity, really, what we're trying to achieve there. We haven't put on defined sizes. It's not something we've necessarily sought to put in the policy. So maybe if you feel, Madam, that it's something we should consider, we can perhaps consider that.
I think one of the concerns would be, as it were, it's an increasing pushing at the envelope of what is acceptable in these lower tier settlements, because unless in a sense, it sounds as it were superficially attractive, as Mr. Short puts it. Well, it's a small terrace of 3 units, and if they were all small units, they might not in bulk terms take up any more space than a semi-detached pair of dwellings. But unless one then stipulates the floor space size for the dwellings, what you end up with is allowing 3 dwellings. And 3 dwellings could then come in a variety of different dimensions. And whether it was stipulated that there had to be a terrace, and somebody would say, well, why does it have to be a terrace? What's wrong with a pair of semis and then a single house turning the corner? And so on. I say it's really comes back to this question of looking at those hamlets and what is appropriate to this lowest scale of settlement in the settlement hierarchy, and wanting to allow for some growth, but not undue growth. And we think we've got the balance right. Obviously, Madam, ultimately it's a matter for you, Mr. Rivet, to think about that in the context of the overall supply of housing, your understanding of the character of those smaller settlements, and whether there is actually a need in terms of making the plan sound to provide the greater flexibility that is being sought by some of the objectors, or whether that's an unnecessary step because the plan isn't unsound without that addition. And we clearly take the view that it's an unnecessary further step.
Mr. Stringer?
Thank you, Chair. I wasn't going to speak on this item, but being a self-builder that's actually built a terrace of 3 houses, I thought I might add something to the debate. What I think it's important to point out is how remote some of these areas are in terms of sustainability. Virtually all of these areas were not inside the 1998 local plan. And indeed, an awful lot of the villages, even in the 1998 local plan, were completely ruled as countryside in the core strategy and subsequent reviews. So even putting a settlement boundary around clusters of 10 houses is a huge letting out of the rope, as it were, and an extension of where we are defining as potentially sustainable. And I think I certainly would see a huge amount of potential for ambiguity and obviously fees from all sorts of consultants by using the sort of adjacent to, although we do have a policy that would allow adjacent to a settlement boundary. That's the one if you want to build purely affordable housing. So even by having a clear, tight settlement boundary would not rule out the potential of development here if the local need was demonstrated. And equally, I think if you were going to amend the wording, I think you could probably insert the words would usually, because yes, just saying one dwelling or a pair of semi-detached dwellings could be deemed prescriptive. But of course, as the inspector will know, that every planning application is dealt with on its own merits, and I'd imagine the ability to put 3 detached dwellings or terrace dwellings in an infill site is probably going to be very, very small in number. And of course, there are always exceptions, and everything's treated on its own merits. I hope that's helpful, Chair. Thank you.
Thanks very much. Mr. Hewitt, you want to come back?
Yes, thank you. Just in relation to the definition of the word infilling, and it would seem that the council are quite focused on a very tight definition of that word, but we do see a lot of examples going to appeal where it's being argued that there's a house on one side of a plot, and then there's a road frontage, and then there's another dwelling on the other side of that road. So the argument is that you have actually got houses on 2 sides, but just not next to on both sides, and whether that's the sort of site that would be resisted, or is there a wider definition of infilling being considered here, or should it be?
Thank you. Is there anything else anyone wants to say about infilling and or on this policy generally? I mean, I want to go away and think about what's been said in terms of infilling and adjacent, and decide whether I think the plan is sound as it is. But is there anything else anyone wants to say about LPO1 before we move on? Lady Hart?
Just on the wording of subparagraph A, it says it would not be detrimental to the character and appearance, and heritage is listed there. And then in paragraph D, it says special regard should be given to development proposal preserving and enhancing the area of outstanding natural beauty. There seems to me, Chiltern Parish Council and I had raised that detrimental was inconsistent with the wording in LPO 3G, where that wording said where a proposal affects and harms a heritage asset, the local planning authority will resist the proposal. Also, the weight that's given, there seems to be a higher weight given in D by special regard, which special regard under the Listed Buildings Act 1990 means great weight should be given. So there's a higher weight being given to the area of outstanding beauty than there is to a listed building or another heritage asset or a historic park or garden. And that seemed to me a bit inconsistent, that A was inconsistent with LPO 3G, I think it is, yes. And also why wasn't special regard being given to the heritage assets, as indeed is required under the Listed Building Act 1990, section 66(1).
Thank you. Mr. Short, would you like to, you've got your hand up.
Yes, thank you. There's a couple of points I'd like to pick up on following on from the representations that have been made. Firstly, the phrase adjacent to and adjacent to existing settlements appears in numerous places in the framework. So if it's good enough for national policy, I don't see why it's suddenly too ambiguous to be used in the local plan. Secondly, in terms of the other subparagraphs of this policy, there's a lot of inconsistency with these and other policies in the draft plan. So, for example, in subparagraph A, in terms of heritage, it cannot be detrimental. But of course, we know from the framework that we have to balance any harm against public benefits. In terms of within the plan itself, subparagraph D requires proposals to preserve and enhance the AONB, whereas the dedicated policy LP20 only is supposed to conserve and enhance. Subparagraph E says that all new development will be expected to minimise dependence on fossil fuel, etc., whereas the dedicated policy LP25 says that all development is required to minimise. So I just wondered if we ought to be consistent with terminology, or better still, leave those issues to the dedicated policies themselves.
Thank you. Is there anything, would the council like to come back on the comments from Lady Hart and Mr. Short about some of those issues?
Okay, Madam, perhaps if I start with the overall points, and then Mr. Hobbs can come in on points of detail. Obviously, so far as the statutory duties of the Listed Buildings Act apply, they apply irrespective, so that the plans policies are not in substitute for the statutory duties. They are in addition to the statutory duties. So I don't think anybody needs to worry that this is in some way a watering down of heritage protection. I say the statutory duties will apply irrespective. And conversely, the AONB, which I think was the genesis of Lady Hart's comments, effectively, although there are, as it were, broad statutory duties in section 85 of the Access to the Countryside and Rights of Way Act in relation to the AONB, they're not as focused as the heritage duties in the Listed Buildings Act, and therefore policy is a sensible place to provide what you might call flesh on the bones, which is what we have done. Then turning more to Mr. Short's points, first of all, the plan needs to be read as a whole, and therefore the policies are read collectively, and we think that when they are read collectively, that will deal with any apparent tensions that Mr. Short has identified. And then secondly, so far as the point about adjacent being good enough for the NPPF, so why isn't it good enough for this plan? Of course, Madam, as you will know, as indeed will Mr. Short, that when paragraph 79 is dealing specifically with the topic that we are dealing with here, that is to say, growth in the rural areas, the last sentence of paragraph 79 is very clear. Where there are groups of smaller settlements, development in one village may support services in a village nearby. And the view hasn't been taken that in relation to residential development, a more expansive approach should be taken. And that can be contrasted with paragraph 85 of the NPPF in relation to economic development, where paragraph 85 is clear that policies and decisions should recognise that sites to meet local business and community needs in rural areas may have to be found adjacent to or beyond existing settlements. So although Mr. Short is correct that the NPPF does use adjacency as a concept for some land uses, in the specific context of development for housing in rural areas, it takes a stricter approach of looking at what is in the settlement concerned rather than what is adjacent to the settlement concerned. So I say, if perhaps now, if Mr. Hobbs wants to bring to bear any particular local comments based on the way that development management experiences sort of, as it were, informed the approach that's been taken in the formulation of LPO1.
Thank you, Madam. The only comment I really have is just to emphasise again this sort of plan-led approach to development, and yeah, that's what we're trying to achieve through this policy.
Thank you, Mr. Short. Did you want to come back?
Yes, it was just one point, which is that adjacent to is used in the framework in the context of housing development, albeit for entry-level exception sites, paragraph 72. So just to have, so you have everything in front of you, Madam, it's not just in terms of a general concept and economic development, it does apply in the framework to housing development as well.
Thank you.
Well, with respect, that reinforces the point that I was making. For general housing development, the NPPF does not take that approach. Rural exceptions are by definition exceptions to the general approach.
Thank you. Lady Hart?
Apologies, I didn't unmute promptly.
It's all right.
If I can come back to address Mr. Bedford's point on the listed building, that special regard would apply because of the statutory duties in any event. But there's a specific provision for NOB in D. I accept that there's a statutory duty under the Listed Building Acts, but sometimes it's not necessarily recognised by members sitting on a planning committee. Also, this policy does not specifically deal with special regard to historic parks and gardens. They're not protected by the Listed Building Acts. And in A, there's no mention of significance of an asset, so it's detrimental to the character and appearance, but not to the significance of the heritage assets. So I go back to, it's a bit inconsistently worded, and I think the policy should be consistent. So we've got protecting and enhancing biodiversity and geodiversity, nothing about historic parks and gardens. Chiltern and I are sensitive to that because we have one of the 5 historic parks and gardens in Baber within the parish. Thank you.
Thank you. Mr. Hobbs, do you want to come back on that?
Thank you, Madam. Yeah, I mean, we can consider adding in reference to heritage if it makes it more clear into point D. Because we're obviously already referenced it in point A.
Yeah, well, if you want to have a look at that and come back to me with possibly with some suggested wording.
Okay.
Lady Hart, oh no, you're just taking your hand down. So is there anything else anyone wants to say about LPO1? Because I think I've got all I need to know, unless there's anything else anyone wants to raise. Right, so shall we turn to LPO2 now, which is residential annexes. Mr. Stringer, I wonder, I know that you've raised some concerns regarding particularly criteria 6 of this policy. I wondered if you could briefly outline them.
Yes, we've had this come up a number of times historically where we've had plans in for extensions, which will obviously hit modern building regulations, but the dwelling it attaches to is far from that level of insulation, or environmental performance, yet we were unable to impose any conditions that would actually bring about any improvement at all to the existing building. Whereas we felt that if we are going to meet the targets that we have set locally, nationally and internationally regarding fuel efficiency and environmental protections, that at least if a homeowner or a developer is looking to extend an existing building, that at least a proportion of the investment in that should go into improvements on the host dwelling, if obviously it were an underperforming dwelling. Because what we will end up doing then, if we are going to meet our targets, it will then mean that public money in the future will have to be pumped into the original host dwelling to bring it up to standard if we are to meet those targets that we have already set ourselves.
Thank you.
And obviously we put a target in there, sorry, of up to 10%, recognising that it would, in some instances, the extension could be £10,000, but in some instances the modifications could be double or treble that. You know, we're trying to be reasonable with this, and even to get that person investing in this extension to actually think about the original dwelling as well, because often it appears that that's not been thought about. Thank you, Chair.
Thank you. What would the council would that say in response to that?
I think again I'll defer to Mr. Hobbs on the detail, but I think in first point is that when one is considering a development proposal, you can obviously take into account material considerations in relation to that proposal. It's not in itself an opportunity to, as it were, seek betterment in relation to something which is not the development. So there would be some difficulties, I think, conceptually, in, as it were, requiring as it were, whole-scale upgrading of an existing building simply because the development proposed is an extension. But then secondly, there is separately, as you know, Madam, policy LP 25, and that would be applied effectively on a case-by-case basis, depending on what the extension proposal was. It applies to all new residential development in criterion 3. And I suspect it may be horses for courses, because there may be some development that falls within LPO3, which is you need to apply the policy to the host building. That's particularly going to be the case where it's a conversion. There are going to be others where I say there may be a challenge in terms of the materiality of applying the new policies to a host building which may not be itself being changed, other than by the fact that, as it were, on one flank or on one elevation, an extension is being applied. So I think we would say that the way that we've formulated it, it's sufficient. You will read LPO3 together with LP25, and therefore we don't think that it needs to be supplemented by adding in additional criteria. And then I say, if Mr. Hobbs got any further comments.
Thank you, Mr. Bedford. Thank you, Madam. No, just to echo that point, really, the plan to be read as a whole, obviously be very a variety of proposals for annexes or extensions that need to be considered on their own merits.
Yeah, thank you. Is there anything, Mr. Stringer, you want to come back with on that?
Yeah, understand exactly what's being said, but in reality that doesn't work, because the host dwelling is normally, for instance, the supplier of the heat to the extension, for instance. So the host dwelling is material to the extension because it will be supplying the heat source. And the difficulty you then have, the planning regime does not allow you to condition that any internal doors will be kept. Therefore, you would then have a heating system which is trying to supply part heat to an efficient building while having to serve basically also a leaky sieve, which means the heating system will not work at all efficiently because there has been no level of integration. And as I say, we have local targets. Our council has declared that we need to address our environmental use of fossil fuels before 2030 within this plan period. And if we are not able to affect or even get householders to consider the environmental impact of their host dwelling, if they're extending it, then it's a greater likelihood we will either fail to meet that target, which we've signed up to locally, nationally and internationally, and equally it will end up meaning that we as a country will have to then use government subsidy to then make sure this happens, which is I would say is unsustainable development. Thank you.
Thank you. Do you want to come back on that at all, Mr. Bedford or Mr. Hobbs?
Well, I think yes. I think on the first point, yes, that question of materiality, there will be some circumstances, as I think I indicated, where you will be able to say that the development and the host building can be treated together because of an interrelationship between them. There will be others where they can't. And so I think it's not appropriate to have a position of it will always be one or it will always be the other. So that was the first point. And then the second point, it still stands that LP25 will be applied as appropriate to the form of development that is being put forward.
Thank you. Well, that gives me plenty to think about on that issue. I want to go away and think about. Lady Hart, is there anything? I know that you and the parish council suggested a number of detailed wording changes. Can you explain why you think the plan is unsound without the wording you're suggesting?
Well, it's partly inconsistency as well, madam, with other policies. So if you look at LP01 that we've just looked at, in this policy, it's much clearer. 4 says where a proposal harms heritage assets, the local planning authority will resist the proposal. I'll come back to resist. So there in 4, you've got harms, which is consistent with NPPF. In LPO1 paragraph A, you've got it would not be detrimental. Why is there a different standard being applied into windfall development in hamlets than to residential annexes? We supported paragraph 5 about the proposal not causing the felling or any damage to significant trees in LPO1. But why isn't that equally required in LPO? Sorry, we supported 5 in LPO2, which is about the felling of trees, and we queried why wasn't that equally in LPO1, so that if a significant tree was under threat of felling for development within the hamlet, shouldn't that equally be applicable? And then in 6, which was the proposals that are considered acceptable are required to minimise dependence on fossil fuels. And I think this is a point another speaker brought out. In LPO 1C, it says all new development will be expected to minimise. And I would urge that in support of the climate change policies that the LPA already has in its core strategy, that wording in LPO 1 should reflect the wording in LPO 2 and other policies, that it should be required to minimise dependence. I can't see why there's a lesser standard applied to hamlets than to residential annexes and extensions and conversions. And we had a query, what does resist mean? Elsewhere in the policy, there's reference to refusing proposals. We would have thought that if it's going to harm heritage assets, it should be refused, we're not clear what does resist mean, and perhaps the council could explain that, but it's a lesser standard. So could it be that they would object to the and not recommend approval? But that then leaves it in doubt. So we would urge clarity and to put refuse the proposal, not resist, which is ambiguous. And that's why we think it's unsound, because it's inconsistent with a whole number of other policies, and it's ambiguous in parts.
Thank you. Would the council like to respond about these inconsistencies in the use of the wording?
I think going back to LPO 1.E, I mean, to be expected to, if it's clearer, we could propose to remove that wording to be consistent. And in terms of other inconsistencies, we can have a look where it's just use of language rather than principle. But I think in terms of the point resist, I mean, this comes back to planning balance on the heritage harm in the relevant proposal. So that's why we've got resist and not refuse.
Well, certainly, can you have a look at some of the different kind of just nuances in the words you're using in the different policies, and make sure that we've got consistency in between them. So we haven't got inconsistency between them.
And could I just ask why if significant trees are to be protected in certain policies, why would they not be in hamlets?
I think this comes back to the point as well of reading the plan as a whole. We do have a specific policy on LP 18, which we'll come on to under the environment matter around biodiversity. So again, that's having a look at the consistencies between each of the different policies. But LP 18 is there for that matter.
So there wouldn't be any harm in making it clear and having such a provision in LPO 1, would there? And in the other policies where it's missing, because elsewhere as well, in other policies, you've got a requirement in these residential policies, you've got a requirement for high quality design. In LPO 3C, you've got a requirement for provision of a high quality design, but you haven't in LPO 2 or LPO 1. And it would seem to me that the council would want high quality design in both of those circumstances equally.
Madam, I think we would say, as we have said on a number of occasions, you have to read the plan as a whole, and it should not be assumed that just because a form of development is being proposed that falls within LPO1, that's the only policy you need to look at in order to decide whether the proposal is or is not in accordance with the plan. What LPO1 has done is set out criteria that are likely to be particularly significant or relevant when one is considering a windfall development within a hamlet, and so drawing attention to those criteria. But it's not saying that there are no other policies which are relevant. And if one made LPO1 effectively an all singing and all dancing policy that covered every single relevant issue that could arise when one was considering a proposal, it would be a very long and very unwieldy policy, and it would be unnecessary to do that. When I say the starting point is you read the plan as a whole, and what you're interested in is whether the proposal is in accordance with the plan taken as a whole, and I say that's the statutory obligation, and it's therefore not necessary within each individual policy to set out all of the criteria that are relevant, and it should not be inferred or implied that, for example, because trees aren't mentioned in LPO1, that therefore it's acceptable to remove trees. It wouldn't be if to do so would bring you into conflict with another policy, e.g. LP18. And similarly, in terms of good design, it's not to be read as meaning that good design isn't important when one is considering windfall development in hamlets, but it's not necessary to say that in that policy because it's already dealt with in a different policy. So I say that's our basic approach, and that's what we have tried to set out when we formulated the criteria.
Madam, may I come back on that?
Thank you. Yeah, what would you like to say, Lady Howe?
My experience is through attending planning committee development committee meetings, that often what is said is that there's a primary policy, and if it's not in the primary policy, even though it's the development plan as a whole, more weight seems to be given to the primary policy. And I can't see why there's an objection for purpose of clarity. It wouldn't make LPO1 any unwieldy by adding in high quality design and protection of trees in there. Because otherwise there'll be an argument that it's not in the policy itself, so it's not applicable. I've argued in the past that the plan needs to be read as a whole, and the answer's been that that it's not in the primary policy applicable. Thank you.
Thank you. Well, I think unless you particularly want to come back, I think I've got plenty to think about there and to consider. I mean, I've asked you to look at some wording where you have got inconsistency between the policies. Otherwise, you know, in terms of some of the ones that have been highlighted. But is there anything else? I think I've got everything I need to know on LPO2. So unless there's anything else, we can move on to. Is there anything anyone else wants to say about LPO2? Right, well, it's just about 11 o'clock, so I'm going to suggest we take a break now for half an hour. Can I just remind you all to switch off your cameras and put your microphones on mute whilst we're on this break, but don't leave the meeting unless you've finished making all your the points you want to make on these matters. Thank you very much, and I'll see you in about half an hour.
Thank you.
Right, it's 11:30, so we will resume and we'll move on to looking at policy LPO3, which is residential extensions and conversions. Firstly, one thing I would like to clarify with the council is that whether all proposals are expected to meet all the listed criteria in this policy, or whether they're optional. Because I think we're going, if it is that they're to meet all of them, I think a modification will be needed just to tighten the wording. So can I just clarify that with the council? I don't know whether it's Mr. Bedford or wants to pick that up, or Mr. Hobbs.
I think the intention is that the criteria that are relevant to the proposal, all of those are expected to be applied. But obviously, if on a particular site, a particular criterion had no application, then, for example, if you had a site that was nowhere near conceivably any heritage asset, then we wouldn't expect to apply criterion G and expect it to satisfy criterion G, because it simply wouldn't apply.
Yes.
But otherwise, we would expect, I think, to apply all of the relevant criteria to the proposal.
So it's not an either or, it's largely all of them that are relevant. Because I think we just you might need to just look at the wording of the of that introductory paragraph, just to make sure that's clear, that it's all that are relevant. And I think it might be worth just looking through the other policies and just checking, because LPO1 did say subject to all the following criteria. So that was very clear that it was all the criteria. So I just think for consistency, I think it might be worth just looking across all the policies in the plan, just making sure you're clear where you want all the criteria to apply that are relevant, and where they're not, and when it's kind of like it's an either or kind of situation.
Yeah, so certainly we can look at that. I mean, I think the basic approach has been that all are to be applied so long as they're relevant, and then in particular cases where, as you say, it may be that there are you've either got to be A or you've got to be B. I think we've tried to make that explicit, but you're also right that we've probably been a little bit inconsistent in our terminology. So some policies in their introduction do say you've got to comply with all. Others don't, and LPO3 is one of them, but we would say it's implicit. But it would obviously be more helpful, I think, to plan users if whatever our house style was, we were consistent in the way we then applied it across the policy. So yes, madam, certainly we can look at that.
Yeah, I just think so, because obviously where some say all, and then if some don't, people kind of think, well, that one says all. This one doesn't, so maybe I don't need to. So I think, yeah, for consistency, if you could just go through and check the wording and come back with the necessary changes that would be are needed. So that's obviously not just the policies that we're looking at today, but across the plan as a whole, just to make sure there's consistency there.
Thank you, madam. Yes.
Now, Mr. Stringer, I know you've got similar concerns with regard to this policy that you had to LPO2. Is there anything else you want to say in addition to what you've already said, or do you feel you've covered what the kind of issues with what you said?
In the interest of brevity, I'm not going to re-rehearse all what I said half an hour ago. Having said that, I would just like to take the opportunity to amplify that. That is even further amplified by extensions and conversions, because extensions normally take the form of building onto an existing building and taking the advantage of existing openings. And it's those openings that will then become internal, which means they're not part of the planning process, that can then be removed, so that if you do have a leaky, inefficient building, no matter how good the extension is in terms of environmental performance, it will be disastrous to try and achieve any form of efficiency and to minimise the use of fossil fuels and fuel in general, which will cause a further strain on what we would deem as sustainable sustainability in building. That's basically what I wanted to say. Thank you.
Right, yeah. Thank you. Thank you for your brevity. And is there anything in terms of, does the council want to come back? I mean, obviously we discussed this under LPO2. Is there anything else you want to say at this point, or?
Madam, no, I don't think we would say anything different to what we've previously said.
Right, yeah.
Can I just push back slightly on one element? So when you in Part G, when you mention cumulative effects, then environmental sustainability is not one of those cumulative effects.
So what in Part G?
Yeah. The cumulative effects of a number of extensions, but by implication, then you mean that that doesn't matter about the environmental performance of the overall structure. That's purely visual and residential amenity.
That's in Part B. Is that right? If I've got that right, Mr. Stringer?
Right. Yes, I was a bit confused there. So
yeah,
Part
sorry.
B,
It was in G in the original draft. Sorry.
Right.
Sorry.
So Part B, your so what was your question, Mr. Stringer? Sorry.
Yeah, it was. So is the environmental performance of the overall building not one of the cumulative effects mentioned in that policy?
Right. What would you like to say? Okay, so
I think we would say that obviously it would be a matter of planning judgment in any given circumstance, but I think we would say that it would be generally unlikely that you would be considering the overall environmental performance of a number of different extensions or conversions because of in a sense, the difficulty of formulating a rational proposition as to why those others are material to the one that you are actually considering, because obviously the basic point being that each proposal is considered on its own merits. Having said that, and without in a sense wanting to be drawn on specifics, there might be circumstances, let's say that you've got a cluster of, let's say, former industrial buildings or former agricultural buildings, which are all being proposed for conversion, but they come forward, as it were, on a piecemeal basis. Then there might be circumstances where you might want to then consider the cumulative effects of anything that's material, which could include energy performance in some circumstances. I say it's a little bit difficult to be precise because it will depend very much on the circumstances, but I think the general view would be that the energy performance of a building would be considered on its own merits rather than the energy performance of that building in conjunction with other buildings.
Can I come back on that? You said in your earlier, when we looked at LPO2...
Can you address your questions to me rather than to the council?
Sorry. It was said in the earlier submission under LPO2 that we couldn't look at the host building in terms of its energy performance, which is why we couldn't condition that it should be looked at in terms of improvements with any approved extension. So I'm still very confused why it can not be taken in the round as part of general policy, but can be taken in the round as almost an exception on its own merits, when I'm still struggling to see where we couldn't avoid the circumstance where you've got a host dwelling which is poorly singly glazed and basically a heat sink, which is an environmental disaster, where we don't approve one or a series of extensions on this that in their own right perform well in energy efficiency terms, but have a huge void into this leaky space, which renders them totally unsustainable and nothing but a burden environmentally and in every other. I cannot see why we cannot have a policy that would help address that situation, which is, frankly, it's a double check. So if someone's going to invest £30,000, £40,000 in extension, often people's motives might be, oh, we'll have a lovely extra room, when in fact we all may be better off if they were to spend a fraction of that money insulating what they've already got. We have civil unrest as we speak because of our failure to insulate our homes properly. And if we are truly going to bring about sustainable development, surely we should at least be expecting an element of new investment to extend an existing house to at least redress an environmental horror story that may already exist. Thank you.
Yeah, I've got your point. I mean, I think is there anything else particularly the council you want to come back on? I mean, you've addressed that largely, but if you want to say anything more.
Yes, just briefly, I think I was trying to draw a distinction in my earlier remarks between the materiality of considering the host building in an extension case and the separate question of conversions, where clearly the conversion will incorporate the host building and therefore the whole of the proposal, changes to it. So that was one scenario. In my more recent response on LPO3, where I was giving an example where I was saying, well, it's possible that the cumulative energy performance might be relevant, I was specifically talking about, as it were, a sequence of conversions. So it's the conversion case rather than the extension case, which I hope I was dealing with in both of my remarks, and I hope they were consistent. Yes, the basic point is, as Madam, I say, we've said before, clearly the proposal, whatever it is, has to be considered on its own merits, and therefore what is material has to relate to that proposal rather than some wider circumstance.
Thank you. Well, I say I will consider that alongside the issues that has been raised under LP2 and come back to you if I consider main modifications are needed. But also on LPO3, Mr. Short, I wondered if you could briefly elaborate on your concerns regarding barns and other rural conversions that you've raised.
Thank you, Madam. It was just a case of, well, if I'm advising a client in terms of a potential application for a conversion of an agricultural building, not just barn conversions, but any agricultural building, there isn't a specific policy in this plan that I can see. And I'm happy to be corrected by the council if they can direct me to it now, as to which policies would actually apply in that circumstance. It just seems, if it is, as I say, I'm happy to be corrected. It just seems to be a needless omission when it could quite simply and quite quickly be included in the plan.
Would the council, would you like to come back on that?
Madam, briefly, I think the approach is, as obviously there are permitted development rights which will apply in some circumstances. I think it's class Q may be potentially available. We haven't, as I think Mr. Short has correctly identified, we haven't got a specific policy which is, as it were, promoting conversions of rural buildings to residential uses, and that is largely because outside of the permitted development rights and therefore buildings which don't fall under that limitation, we're not actively encouraging the conversion of such buildings to residential uses. We do have policies which are permissive of their, as it were, repurposing for economic purposes, for leisure and tourism purposes, and we think that's a more sustainable use of such buildings in the rural area. We're not, I say, generally wanting to encourage residential development in relatively remote rural locations, so we don't have a policy which specifically tries to bring forward that form of development. I don't know if Mr. Hobbs wants to then add anything further on that.
No, I have nothing further to add.
So largely applications that come up in the open countryside would be dealt with under the NPPF kind of policy, paragraph 80. Would it, I presume, therefore, is what you're saying? You're on mute, Mr. Bedford.
Thank you, Madam, and I apologise for that. Yes, obviously national policy will be applicable in the plan area as indeed elsewhere, but it's not a particular form of development we're trying to encourage by having a bespoke policy.
Is there anything, Mr. Short, you want to come back on that? Yeah.
Yes, if I may, as the council has indicated several times this morning, this is supposed to be a plan-led approach, and therefore by simply deferring back to Class Q permitted development rights and saying that's all that you can have, is that consistent with the plan-led approach? Secondly, if I was to put in an application on behalf of a client for a barn conversion or for another conversion of an agricultural building to a dwelling, and again, this might be something which Mr. Bedford can clarify, if there is no plan, there's no policy in this plan, are we automatically in 11D because there's no policy for a conversion, or are we to do so? I mean, what would we do in that circumstance?
Mr. Bedford, would you like to reply?
I think we would take the view that if it was residential development, it is covered by the plan, and we would look at the plan policies in the first instance and ask ourselves, is this a location where the plan is permissive of residential development, or is it a location where the plan is not permissive of residential development? So I don't think we'd be in a paragraph 11D scenario. The plan would be saying something when you take into account the form of development. And I say, I repeat, it's not a form of development we're particularly trying to encourage, and so we don't have a bespoke policy setting criteria for it.
The other Mr. Short, I think, has got his hand up now.
Small point. Class Q, of course, not all agricultural buildings are remote, as has been inferred. Secondly, Class Q is subject to a number of exemptions. So in the case, for example, where the host building is a listed building, permitted developments wouldn't apply. And therefore, I guess, again, the council is saying that in such circumstances where Class Q is not available to an applicant, they would have to refer to or rely upon paragraph 80. Just seems an omission of policy to me, because there are a whole host of rural or redundant or disused buildings, not necessarily an agricultural use, which have provided a source of residential dwellings towards the council's housing land supply in previous years.
Anything the council, do you want to respond to that? Or just leave it to me to think about?
I don't think we got anything particularly further to add. I say we recognise that Class Q doesn't cover everything, and clearly things which are outside of Class Q will need to be the subject of a planning application. I think we set out our position as to what our approach is to those type of rural conversions where a planning application is needed.
Yeah, thank you. Well, I think I've got everything on that. I will give that further consideration as to whether that is an omission and that would need to be addressed in this policy or separately. And also the comments by Mr. Stringer. Is there anything else on LPO3, sorry, before we move on? Yeah, Lady Hart. You're still on mute at the moment.
Apologies, madam. I haven't pressed it hard enough. I'll stop it the next time. Paragraph B contains negative wording, will not result in overdevelopment of the plot. Generally, the Chiltern Parish Council is supportive of this, but in the NPPF, and if you'll forgive me, the February 2019 version, because I haven't got enough devices open to be able to look at the July 2021 version, in paragraph 192, there's a new development encouraged to make a positive contribution. Sorry, it's 192C, and it's a positive contribution to local character and distinctiveness. And it would be good to have some reflection of that in this wording. Because there's in C, there's incorporate good quality design, which maintains and enhances the character and appearance of the building, but and then reflects the relationship of the site. But it doesn't go. It doesn't deal with local character and distinctiveness specifically.
Yeah, so I think that's paragraph 197 now in the revised MPPF.
Right, thank you.
It's all right, so just so that everyone's clear if they're looking at the other one. So you're thinking that you're suggesting that the local character
and distinctive, just to have some wording to reflect the requirement for a positive contribution to local character and distinctiveness, rather than just the negative. I think it's just a question of adding in that wording, really. So it should be a simple adjustment.
Any views on that from the council?
I think I'd repeat what I said earlier this morning, that you need to read the plan as a whole, and I think we would suggest that heritage matters are adequately dealt with by LP 21, and then LP 25 and LP 26, with LP 26 specifically dealing with design and residential amenity. I think when you take those policies and read those together with LPO3, it's unnecessary to further burden LPO3. I say we simply don't accept that each policy needs to be its own all singing and all dancing answer to an application.
Lady Hart, do you want to say anything more, or just leave it for me to consider?
I'd just like to say, madam, then I will leave it to you to consider that I don't think putting in limited wording would affect it. It would make it clearer to people. And also there's still the same inconsistency. So we've got good quality design for residential conversions and extensions, but not in windfall development and not in residential annexes. So that seems again to me inconsistent. Why is there lesser standard for the earlier two policies? Thank you, madam.
Thank you. Mr. Short, you've got your hand up.
Yes, thank you, madam. It's really just to sort of pick up on some of the points that have just been made. which is that we still have this crossover between other issues when, in my submission, the policies which are only trying to do one thing are those which are simplest and the easiest to follow. And it doesn't lead to these sorts of inconsistencies. As Mr. Bedford has just said, they've got specific policies to deal with those issues adequately. So I think he was talking about LP21 and heritage. So is it really necessary for this policy to cross-reference that, particularly as it seems to apply a different standard? Here we've got a proposal which just affects and harms a heritage asset will be resisted, whereas we know that the framework sets out a balancing exercise of weighing the benefits against the harms. And even if there is harm, provided the benefit outweighs that harm, it can still be acceptable. So we've got an inconsistency internally and also an inconsistency with national policy. So I just wondered, that's just one example, but there are others in the policy where there's lots of cross-referencing. I just wonder whether that is strictly necessary.
Thank you, Mr. Short. Well, I mean, the council, I have asked the council to look at some of the inconsistent, if they have got inconsistent wording. So hopefully you may pick some of that up. And I'll give further thought to about the issues that have been raised in terms of whether we need what we need, and in terms of, and we'll be discussing LP21 next week in detail as well. So we can consider that again there.
Yes, thank you, Madam. Given particularly that LP21 isn't on the agenda for today, and as you say, is a matter for next week, I'll since reserve a more detailed response to them. But just on the point about inconsistency with national policy, we don't accept that the heritage policy is inconsistent with national policy, and it's not necessary for it to have that reference to balancing against benefits within it. And I think that issue has been the subject of some consideration by the courts in terms of whether development plan policies need to be, as it were, identical to the NPPF in order to be compatible with the NPPF. But so that's perhaps more a matter that we can pick up when we come to look at LP21 next week.
Yes.
But but your wider point about wanting to adopt a consistent approach, certainly we recognise that, and we will, as you've already asked us to do, we'll look through across the suite of all of the policies to try to iron out areas of apparent inconsistency.
Yeah, thank you. So before we move on, is there anything else anyone wants to raise regarding LP03 then? Right, well, we'll move on to LP04, replacement dwellings in the countryside. Some minor points to start off with. I just think there's, if I just get it, page. I think I've noted a couple of typos that will need to be picked up under additional modifications. I think it might be helpful in you cross-reference to LP01 in terms of in the first paragraph. You say policy, residential extensions and conversions policy. I think it might just be helpful to put in the number of the policy, and I think that's the same on LP05 as well. And clause D, criterion D, I think needs to pick up the changes to LP01 that has been suggested in terms of removing clusters and just dealing with hamlets. But I particularly like to look at clause C in this one, and comments have been made that the blanket restriction on demolition of heritage assets in this criteria goes beyond national guidance, which does allow demolition in some circumstances. And I just wondered what comments the council would want to make on this.
Mr. Hobbs starts on the local thinking behind that, and then I'll add some further comments at the end.
The thinking behind it is that the districts have a large number of heritage assets in the areas, so we're sort of seeking to sort of preserve those where we can.
But if it but the suggestion is that it goes beyond what national guidance is saying. Mr. Hobbs, what's your view on that?
Well, I mean, I think in terms of the basic approach, we would say it's first of all, national policy will be applicable in addition to the local policy. The local policy can deviate from the national policy where there are local circumstances which suggest that that is the case. As Mr. Hobbs has outlined, the council has taken the view that it has a wealth of heritage assets, including designated as well as non-designated heritage assets, which it would be desiring to retain, and therefore see them repurposed rather than replaced. And we think that that is a sensible, as it were, drawing of a balanced approach, and therefore we're not wanting to encourage the loss of heritage assets, albeit obviously if there were circumstances where a building clearly had no capable future and such a proposal were to come forward, it would be dealt with as a departure from policy, but we're not, in a sense, trying to encourage that outcome for the reason that I've indicated.
Does the council have or do the councils have a local list to define what they consider to be non-designated heritage assets at all? Because obviously it's quite wide, and it talks about building of historical or architectural importance and merit, or a non-designated heritage asset. I mean, like that could cover how's a developer going to know whether the building they're dealing with comes under one of those categories? I mean, or is there a local list?
So I'll ask Mr. Hobbs if he can clarify that.
Yeah, that's something that will be enabled through this plan. At the moment, we have mixed coverage. There's a couple of local lists that currently exist. What a lot of neighbourhood plans, for example, are doing is introducing lists through that mechanism. But that's effectively what we're trying to encourage, that environment where applicable.
But I mean, how would a developer know whether their building is, going to be considered a non-designated heritage asset if it's not under one of these neighbourhood plans? Or yeah,
it'd only be at the point of where it's designated. So if it hadn't, if it was being designated as a non-designated heritage asset, if that makes sense. So where it hasn't been identified as that, then obviously it wouldn't be known.
Right. So it would only cover the ones that are in a neighbourhood planner or one of these informal local lists. No. Do any of the participants have any comments on the approach of LPO4? Lady Hart, you've got a comment. You're still on mute again, Lady Hart.
So sorry.
All right.
I clearly am not hitting my screen hard enough.
Don't worry.
Just on, in case it's of any use, I do know that Suffolk County Council maintain a local list, but that is of the designated heritage assets. As far as I'm aware, I don't know that it extends to non-designated assets. It might do, but they do maintain, Suffolk County Council maintain a local list. I don't know that BABER itself maintains a separate list. So several of the designated heritage assets within BABER are both on the National Register maintained by Heritage England and on the local list. And just coming back to the wording of LP04, I haven't got any points on C, but what I wonder, I feel Chiltern Parish Council consider this policy is weaker than the existing policy in the core strategy. And unfortunately, on my notes, I cannot find now the reference to the existing policy, but the existing policy has wording to the effect that the replacement building mustn't be of a different size to the original building. And here in A, it says that design, scale, etc. Must be compatible to the area's character and appearance and no more visually intrusive to the original building to be replaced, but it doesn't deal with the size of the original building. And so you could have a subjective argument that a much larger building is not more visually intrusive. So we consider that some of the wording that was in the past plan should be reflected in here. There was wording to say that there was a significant that an increase would be considered significant if it was more than 30% increase over the original building. But now there's nothing in this policy that restricts to that, and it's particularly come to Chiltern Parish Council's attention because we recently had an application for replacement building of a bungalow by a considerably larger building. It was turned down. It was refused, but it's been refused. There've been 2 applications been refused by the council under the existing policy, but query under this, and it was substantially larger and was objected to, but query under this wording, it wouldn't have been as clear.
Thank you. Would the council like to respond on that?
I think, again, subject to anything that Mr. Hobbs wants to add, I think in the first instance, we would say that when you read criterion A as a whole, it contains sufficient judgment-based factors that would avoid what you might call disproportionate additions, because it's not only making it clear that whatever comes forward has to be compatible to the area's character appearance, it also has a criteria that it shouldn't be more visually intrusive than what it's replacing. And lastly, it has a criteria that it mustn't significantly urbanise the plot or the property curtilage. So that taking those, as it were, together, we think that they would adequately capture a disproportionate addition. But then there's the difficult issue always comes is that, yes, they are judgment based, but if you were to adopt Lady Hart's approach of having a specific percentage, which you do see sometimes in certain policies, or of having a specific square meterage, which again you do sometimes see in certain policies. The issue then arises, well, what's the justification for that particular limitation, and why 25% or 30% and not 35% or 20% or whatever it may be? And in a sense, there's probably no right or wrong answer to that question. It comes back to a question of judgment in what is going to be an effective policy. We think we've got the balance right. We don't think that the policy is unsound because it doesn't have an arithmetic component to it. Obviously, that's a matter that you have to take a view on. Anything from Mr. Hobbs, if I can just clarify?
Nothing further to add, no.
No, thank you.
Mr. Short.
Thank you. I think the council's policy as drafted should be endorsed, simply because something may come forward as an application that is 3 times, or whatever the factor is, the size of the original dwelling, doesn't per se mean that it will become more visually intrusive. If you have a secluded site which is not visually obtrusive at the moment, enlarging that dwelling by a 3 times factor does not thereby automatically make it more visually intrusive. So I think the flexibility and the balanced planning judgment that's inherent in 1A is the right way.
Thank you. Mrs. Davis.
Thank you, Madam Chair. Just with reference to point D, there must not be any increase in dwellings on the site. We have had an example of a cottage replaced by a McMansion and a supplementary building of a garage going up that was large enough to be a 2-bedroom bungalow, and we strongly suspect that will come forward in due course. So the reference to dwellings, could that be expanded to cover sort of the supplementary buildings that you might consider comes with a new house, such as a garage or storage facilities?
Mr. Hobbs, do you want to come back on that?
Yeah, thank you, Madam Chair. I just wanted to make reference to ancillary buildings are mentioned in the introductory paragraph.
Oh, yeah. There's nothing else I want to add about LPO4. Is there anything else anyone else wants to add before we move on? Right, thank you. We'll look at LPO5 then, which is on replacement dwellings and additional dwellings on subdivided plots within settlement boundaries. I just wondered if the council can explain in criteria G of this why it only refers to listed buildings and not heritage assets more widely.
I think the simple explanation is that that's one of the consistency points that I think we have would expect to be picked up in the exercise you've already asked us to do, because well, I think we ourselves within the team have looked to see whether there was a particular reason why only listed buildings rather than heritage assets more generally was referred to. We couldn't identify one, so we think that's likely to be one of the inconsistencies that we will pick up.
Thank you. Lady Hart, I know that you've got concerns about this policy. Could you briefly elaborate on them and how they impact on soundness?
Okay, well, one was in particular policy G that Mr. Bedford had just accepts that we were concerned that that policy was restrictive, didn't cover other heritage assets or their significance, and it doesn't cover, for example, registered parks and gardens, and also so now I recognise the council are going to reword that provision G, so we thought that was unsound. And also previous iterations of this policy statement provided that replacement dwellings would replace original properties that were habitable. And that wording does appear in LPO 4F in lawful permanent residential use, yet there's no such wording in policy LPO 5. So I think it's probably back to the consistency point.
Yeah. Does the council want to come back on that?
I think there is a difference in that LPO 4 is dealing with a location where in principle residential development would not be appropriate because it's dealing with replacement dwellings in the countryside outside of settlement boundaries, whereas LPO 5 is dealing with circumstances inside a settlement boundary where, as it were, in principle, development may be appropriate. So I think that would be the kind of starting point, that there is a reason for taking a different approach. But I don't know if Mr. Hobbs then wants to add any particular further comments.
Thank you, Madam Chair. There's also the point that it's also LPO5 dealing with additional dwellings as well as replacement dwellings. That was the only point I wanted to make.
Yeah, you want to come back, Lady Hart?
Yes, please, if I may. We've had an instance in Chiltern Parish that where an additional dwelling has been allowed on a replacement plot, which was objected to by the parish council, and no consideration was taken of heritage assets there, despite the statutory bodies objecting to it. So to have a restriction in the wording of G would, it definitely needs to be widened.
Yeah, well, I think that will definitely needs to be looked at. I've flagged it up, so I'm expecting that to be looked at as part of a main modification.
Thank you.
I have nothing else I want to ask about LPO 5. So unless there's anything else anyone wants to raise, we can move on. No, we'll move on to LPO 6. And just to reiterate that we're dealing with parts B and C of LPO 6 because the affordable housing part is being dealt with under matter 3 with the other affordable housing policies. Now, again, there's just for clarity and just a few minor issues that I need to pick up. I think there's the text, the supporting text to the policy. I think there needs to be looked at quite carefully. I think I found some areas where well, I couldn't make sense of what it was saying really. Paragraphs 1328, 1330 and 31. I think you just need to look at, I think there's some words missing, and because it didn't make much sense to me. And I think also the footnote reference in paragraph 1329 is wrong. I think it should be footnote 26 at that point, not footnote 27. So if you could just have a look at that and come back to me with some wording on that. But generally, to the council, I note the statistics you've provided in your evidence, but I'd like to know how this shows a need for M42 over and above M41.
I think Mr. Hobbs is going to comment on that.
Yep, thank you. Thank you, Madam Chair. So, as you point out, we've outlined the statistics, particularly from the strategic housing market assessment, about the growing population becoming more of an older population, and also as SHMARH identifies, requiring more adaptation going forward. So what we've put forward is a 50% requirement that we believe is a reasonable approach to cater for the needs identified in this evidence base. And we feel it's appropriate to have a larger pool of dwellings to meet this need. So we're not saying 100% need to be M42 of general housing stock. And likewise, you know, we feel 50% is an appropriate level.
But how do those statistics show that you need M42 above M41? Because I'm obviously M41 does provide some provision. So why does it show? Why just the fact that you've got an aging population, does it show you need M42?
Well, we have an aging population, but we also have population across all ages that require there's increasing or there's an existing need and an increasing need around mobility that needs to be catered for as well. So it's just good planning judgment to have a degree of M42 properties as well as part of the overall housing mix across the two districts. There's not a map.
What evidence have you got that shows the number of people who would need specifically adapted homes as opposed to being able to adapt their own homes?
We've just got what we've identified in our hearing statement and the topic paper on housing need around the SHMARH. I mean, I don't have evidence to hand right now that would demonstrate that beyond what's already been published.
So how do you justify the 50% figure then? Because I mean, like, how many would that yield in relation to the demand?
As I said earlier, I mean, we're looking at a range. There's not a mathematical formula, so you could argue that between 40 and 60% would be a good range to apply this on, not 10, 20, 30, you know, and likewise we haven't gone for, say, 100 or 90. So that's how we've arrived at our figure. We haven't done the mathematical calculation to say what the precise number should be relative to need, to the demand rather, as you point out.
I think also, Madam, it would be perhaps just worth noting, as I'm sure you are aware, that M41 is obviously concerned with visitable dwellings, whereas M42 is accessible and adaptable dwellings. So as it were, the focus of M41 is not dwellings that are, as it were, in themselves suitable for permanent residence by somebody who has particular mobility or other impairments. It's to enable them to have access, as it says, for them to visit other buildings. M42 is more focused on making sure that a building is suitable to meet a person's needs as a location where they are effectively going to be permanently resident. And in terms of what the planning practice guidance says in, I think it's paragraph ID 63009 2019 0626, it says that where an identified need exists, plans are expected to make use of the optional technical housing standards to help bring forward an adequate supply of accessible housing. In doing so, planning policies for housing can set out the proportion of new housing that will be delivered to the following standards, and then it refers to M41, M42 and M43. And I think we take the view that the evidence that Mr. Hobbs has referred to certainly shows that there is a need for some accessible and adaptable dwellings rather than merely the default position of M41 visitable dwellings. As to what that sum should be, again, as Mr. Hobbs has said, there's not an arithmetic formula that produces a calculation to show that it should definitely be 50% rather than a different percentage. But what there is in terms of that evidence base is showing that there is a sizable proportion of existing need. There is an expectation from the evidence base of a growing need, and then coupled with the viability appraisal work, there is an indication that imposing that proportion would not render the plan's policies unviable. So whilst it's as it were a judgment-based approach rather than an arithmetic-based approach, we think that that is sufficiently proportionate to the issue to be a sound approach. And I say we don't see that that's inconsistent with either the NPPF or the planning practice guidance.
Thank you, Mr. Bedford. Mr. Barrant, would you like to come in?
Thank you, Ma'am. Interesting to hear that the council have looked at the numbers of older people coming forward, and there seems to be an assumption there that all older people will require a more accessible home, and I think that's just not the case in terms of the evidence. And I think what is important to look at is in terms of footnote 49 is that it has to be based on need. So that's the fundamental point at which we have to look at this situation. This doesn't say that no houses should be built to M42. It's just that it should be based on what is actually needed. I think the first thing to look at really is with an aging population is that increase in aging number of households that are older are largely households that already exist within this area. They're households that are getting older. So they will already live in properties within the area. So it's questionable to us whether those who might need a new house will want to move in that, or whether their homes can actually be adapted to meet their needs. And I refer in my statements, Ma'am, to the English Housing Survey, which provides a clear indication that actually just because you're getting older and actually you might have a need, you don't necessarily need to move to have that adaptation to your home. So I think that needs to be, you need to look at that existing stock and how that relates to your need going forward. I think secondly, it's really looking at what is that evidence to sort of suggest that those people may want to rather stay in their own homes and have that adapted rather than move forward. So you need to have a look at this wide range of evidence that's coming forward rather than just the singular we've got an older population, therefore we will need more accessible homes. So I think it's really about the nuance within that evidence rather than just looking at the base facts. I'd also like to say I made my comments under question 5.7c, where I should have been under 5.6a in terms of my statements, just to clarify that position. And apologies, I didn't read the question, which is what I always say to my children in terms of exams. So apologies for that. Thank you, Mark.
Mr. Clough.
Thank you, Ma'am. I just wanted to give Suffolk County Council's view on this policy as the organisation with responsibilities for care. We support the council's policy on the basis that, you know, while it is right necessarily just because the population is ageing, that there are necessarily, you know, people necessarily need to make adaptations to their dwelling. The aging population does also correlate to an increase in complex needs and changing mobility as people age. It's also the County Council's sort of care priority that people should age in place as much as they possibly can. So this isn't necessarily about people moving for the purpose of having an adaptable dwelling. It's about having a stock of adaptable dwellings so that people can age in place as much as possible going into the future.
Thank you. Mr. Stebbings, I think.
Thank you, Madam. I've got some fundamental concerns with the drafting of this policy and also its supporting justification, which I think you've alluded to already. The two don't sit well together, frankly, the policy and its justification. And furthermore, the policy doesn't sit well with the underlying evidence. And despite Mr. Bedford's best efforts just now, I would suggest to you it doesn't sit well with viability evidence. In short, the policy is far too prescriptive, and the word must in clause B should, in my view, be should. You'll hear me say this again with regard to affordable housing, and the prescriptive level of 50% of dwellings meeting part M4(2) of the building regulations threatens the viability of many residential schemes. So we put some suggested wording in the hearing statement to you, Madam, which I hope you've seen. I'm not addressing Part C at the moment, but I request that I'm able to come back to you on Part C, and the tenor of my remarks will be similar on that. Thank you.
Would you like to just outline the kind of the proposed kind of wording that you've suggested so that others are aware of it?
Very simply, for all major housing development proposals for 10 units or more, or sites of half a hectare or more, including supported and special needs housing, where viable, that's crucial, the scheme composition should accommodate 35% affordable housing to meet affordable housing need, and B, should accommodate 50% of the dwellings which meet the requirements of Part M4, etc. I think the County Council would be equally content with that, as they've just expressed their content with the current drafting. Thank you.
Thank you. Mr. Cook.
Thank you, Ma'am. I won't dwell on this too long because the points have been largely raised by others already, as well as yourself. But just wanted to echo comments made by others and your original line of questioning, really. My client's position is not to discredit the evidence that the council refers to, so documents EH02, the SHMAR and the ON topic paper at EP02. I think we accept that there is an ageing population here. It is simply how that evidence subsequently relates to the policy, and particularly the 50%. I mean, it's already been alluded to on the call that it's effectively a line in the sand, and we appreciate that line has to be drawn somewhere. It's not evidenced as to where the line has been drawn. And yeah, that's our fundamental points, really. But I would also echo and support the wording that has just been suggested previously as well. Yeah, that's it, really. Thank you.
Thank you. Mrs. Hay.
Thank you, Mum. I'd like to come back on Mr. Bedford's point relating to the supporting viability evidence. I won't go into too much detail because I have set this out in our supporting hearing statement. However, we do have some concerns with regards to the whether an appropriate financial figure has been accounted for in support of this 50% that is being requested. In the Plan Viability and SIL Review study prepared by Aspinall Birdie, document reference ER02, additional cost of £521 per dwelling has been accounted for. But when you look at where this has actually originated from, it's from a DCLG Housing Standards Impact Assessment dated 2015. And indeed, looking at that assessment, it appears to relate to an even earlier evidence piece from EC Harris Cost Report dated September 2014. And this would suggest that the figure that has been applied for, to which is supposed to justify the requirement for 50%, is indeed approximately 7 years old. And we therefore request whether there's been any further work to essentially, prove that this is up-to-date evidence and that this costing is correct. Thank you.
Thank you. I'll come back to kind of some of the viability in more detail. So if we can just hold that for a minute, because I do want to look at this. I want to just explore this 50% figure, particularly and where it's coming from, and whether it's justified. Mr. Stringer.
Yes, Madam Chair. Thank you. Yeah, I just want to make a couple. Is it okay if I make a couple of points, Chair? I'm slightly confused as to why all of those trying to resist this change are suggesting it's only about an ageing population. To suggest that there's no one with disabilities under the age of 65, I find utterly amazing. I also find it quite amazing that we're arguing about that we should discriminate people from being able to be part of a marketplace. I find that utterly remarkable. When talking of figures, the government figures alone suggest that 1 in 4 of us will need specialist adaptations to our housing due to disability during our lives. That's then basically every other house will need that. And at the moment, the budgets of the existing councils, Mid Suffolk spends almost £500,000 a year on adaptations to existing housing stock. Bearing in mind we're a £10 million operation a year, that's an awful lot of money. If we're expected to keep paying that into the future, that's not a sustainable. We should be building things that people can move into, and whether they have disability or not. I find it remarkable. I had a piece of casework not a few weeks ago where somebody bought a brand new house, a brand new bungalow, because she's only 55 but couldn't live in her cottage because her husband had died and she had multiple sclerosis. They've had to spend £3,500 on a brand new bungalow so she could access her garden. I find that utterly awful that that can happen within the current building regulations, and that the trade should be resisting people being able to do that in the future. I frankly think we should be arguing for these regulations to go a lot further than they are, rather than trying to resist allowing equity in this marketplace. Thank you, Chair.
Thank you. Mrs. Payne.
Thank you. I'll be incredibly brief, given I support sort of the comments that have gone before, and the point that you just noted that we'll be coming back to viability. So that was one of the main points I was going to raise. The one thing I would just like to point out, though, in respect to Mr. Stebbing's suggested change, agree with that, but it comes down to a consistency point picking up between LPO 6 and LPO 7 there, in that criterion H of LPO 7 would suggest that all units in that situation would need to comply with Part M4.2 rather than the 50% suggested in LPO 6. So I'll come on to that in LPO 7 and my views on that. But it was just to pick up, there does seem to be an inconsistency between those two policies, and I'll save my comments on the viability for when you invite those.
Thank you. Yes, we will come back to that issue in terms of LPO 7, obviously when we get to that one.
Yeah, that's fine.
Ms. Davis.
Inspector, sorry to, I put my hand up for.
Oh, sorry, yeah.
Sorry. I'd put my hand up for Mr. Brown, whose hand up facility wasn't working. So Mr. Brown has been patiently waiting in lieu of my name.
Right. Well, after Mrs. Davis, I'll ask Mr. Brown to come in then.
Thank you, Madam Chair. Again, like Mrs. Payne, I'll restrict my comments on viability till when you raise it. But with respect to the 50% adaptable, it's not just disabled people that you need to cater for, or those who become disabled. There has been talk about fit houses that are fit for life. And so they change to meet the needs of the people that come in them. So a couple that moves in when they're in their 20s, they then go on to have kids. They then may say, OK, I want to, build another room on. I want to go up into the roof because we've have another child and need the space. So it isn't just disabled people that you need to consider. And if houses can change to fit the changing needs of the people in them, it's going to probably be more economically friendly in that they don't have to move to another house, and more environmentally friendly as well, because the amount of rebuilding that's done is minimal, and that they're not buying lots of new equipment. So I think the adaptability piece is important and needs to be reflected.
Mr. Brown.
Yes, Mum, thank you. Can you hear me?
I can, yes.
Yeah, sorry about that. Thank you. Mum, I just wanted to just really refer you to paragraph, it used to be 61, but 62 of the framework, which actually confirms, it says within the context that the size, type and tenure of housing needed for different groups in the community should be assessed and reflected in planning policies. I would actually submit, Ma'am, that the council have not made that assessment, and it also seems to me, Ma'am, a little bit of overlap with 07, but it seems to me, Ma'am, that the council's response is to this undoubted acute need. They accept an acute need for care home bed spaces and also I probably described it as retirement accommodation or extra care. But it seems to me, Ma'am, that the council's response in terms of building regulations and I think mention was made about adaptable dwellings, is just totally inadequate. It seems to me, and also the point has been made that it's not just the elderly who suffer mobility issues. I think again that's becoming confused. The needs of the elderly are not addressed, in my opinion, by building regs. My experiences with care homes and extra care and assisted living is that what is important, what is very important, is for example, care packages. When you do get to a certain age, you do need some help, and that can be provided in a variety of ways. But the needs of the elderly are clearly not addressed just by having adaptable dwellings. Also a little bit of an overlap. You have quite rightly referred the council to, you've inquired, just looking at the local plan, Ma'am, you've asked the question about 13.28. You're quite right. What it actually says is that the population age 65 or over is going to increase dramatically. I think probably, Ma'am, that you're perhaps asking the question, well, okay, but what's the response to it? But Ma'am, could I take you to 13.31 of the local plan, because this for me is very, very important, Ma'am. 13.31 and it confirms this, that and it refers to the SHMA. I think there's also other indicators, but it does actually make the point about it says the increasing need for the provision of older people accommodation. Yes, accepted. And then it actually states, Ma'am, it actually states 1,005 additional specialist units will be needed in Mid Suffolk, comprising, and then it gives a breakdown of sheltered housing, enhanced sheltered, extra care. So there is quite clearly, even in that paragraph, there is an identified need that I would say, and ask the council the question, how are you going to meet it? It's not going to be met by just having adaptable dwellings. It also, Ma'am, goes on to make the point, and there's very much an interconnection. My experiences, Ma'am, with the elderly is that I've always, to date, I've been able to work with, having care homes. They're very much linked in to extra care accommodation. And 13.31 goes on crucially, Ma'am, to acknowledge that it says towards the end of it, the SHMA identifies there'll be a requirement for 1670 people in Mid Suffolk, which means an additional 1,004 registered care accommodation will be required over the plan period. It actually says, Ma'am, registered care accommodation. That is not addressed by building regs. It is just not addressed. So it then turns itself round, and you go back to the framework of actually paragraph 60 and paragraph 62. It used to be 61, but quite clearly this is a plan that is not sound. It is a plan that is not consistent with it. And as I say, I understand the motives, but this is a plan that should respond with accommodation that includes care packages and so on. It is not the problem. The need is not addressed by building regs, Ma'am. Thank you.
Are you saying that you need the building regs and other stuff as well, or are you?
No, I don't think building regs addresses the problem. It seems to me, Ma'am, that if you look at paragraph 13.31, I think the figures are actually more than that, but it does give you a starting point. What the council have confirmed at 13.31 is that there is an acute need for care home bed spaces, 1,004, and what I would shall I describe as retirement accommodation. It says 755 sheltered housing, 73 enhanced, 176 extra care. I say that should be addressed. I will come on in 07, Ma'am, to make the point that I believe that sites should be allocated, but this is a plan that needs to respond to 13.31 and it fails.
Thank you. Mrs. Parsons, I will go back to the council and that we're just trying to get everyone who's got their hands up at the moment. So Mrs. Parsons.
Thank you. I think this is a simple issue of the requirement to provide the evidence. It's not about the industry resisting the provision of this. It's a request from the evidence, and from what I've heard today, I don't believe you've had satisfactory response on that particular request for the evidence that you require, and that cuts both ways, because if the evidence were provided, it may show that the proportion required would be greater than 50%. So it is definitely not about the industry resisting providing this type of accommodation. It's simply a request that the evidence is provided. And just to clarify on Mr. Stebbing's suggested amendment, I wouldn't want that amendment to be seen as something to overcome the absence of evidence. I don't think that's what Mr. Stebbing was suggesting, because if it were, then we would have a situation where we would have to provide unnecessary viability assessments to prove something that couldn't be provided, that wasn't evidenced in the first place. So just a note of caution there. As I say, I don't think that's what Mr. Stebbing was getting at, but just in case that were taken that way.
Thank you. Mr. Clay, you want to come back?
I just wanted to respond. There was an implication that the County Council might support what might seem like a weakening of the policy, and I just want to reiterate we want to see M42 housing to be as prevalent as we possibly can to enable that sort of ageing in place ambition, as well as the other needs for people with disabilities who may be younger than that age, as others have rightly pointed out as well.
Thank you. Mr. Stebbing again.
Mrs. Parsons' interpretation of my remarks was absolutely right, Ma'am.
Right, yeah. So given what we've heard, can I come back to the council and again, and particularly on this 50%, and I'd like to really understand where this 50% has come from and how we know it's going to be the right figure.
I think I'll ask Mr. Hobbs to start on that matter.
Thank you. Well, on going back to the need aspect, I'll just refer back to the topic paper that the council's produced on this need, and which quoted the data from the Strategic Housing Market Assessment document, which was EH02, and the topic paper's document EP02, and it contains tables in there with number of people with particular health issues across all ages, and also the population aged over 65 is expected to increase, for example, in Baber by 33%, 8,500 people over the planned period, and 9,200 people in Mid Suffolk, which is 35% of the population over the planned period. So the figures are there, and that's how we've interpreted that. As I said earlier, we've looked at what is reasonable. We haven't done a mathematical calculation, but that's that position effectively. I'll come back on viability at a different time.
But how I mean, like you say, there's no mathematical. I mean, what is there any idea of how, you've set out figures as Mr. Brown's pointed out in like 1331 and 1330 about how many units, the kind of need, how many, if you went for 50%, how many would that provide in relation to that kind of need?
We'll have to look at what's already got planning permission as well, as we've touched on under matter 4. A lot of the suppliers already got planning permission, so we're talking effectively about 50% of the residual amount. We can work out that out and come back to you.
Yeah, exactly. I need to understand, so roughly how, as Mrs. Parsons has said, like, do we know that this is the right figure? It could be higher, or lower. I don't know. We're just trying to understand where this 50% and how it's going to, if it's going to meet the need or not. So yeah, I think certainly some work on is needed to clarify what kind of how much that's going to produce. Mr. Stebbings, did you get your hand up?
I mean, I find this quite remarkable, Mum, that Mr. Hobbs hasn't substantiated at all in his last remarks how the policy gets to 50%, and as you can see yourself, the justification makes no reference. The policy justification makes no reference to 50%. But what I want to hear, and I hope we will after lunch, is how the whole plan viability assessment has taken, presumably, this 50% requirement into account. Thank you.
Thank you. Yeah, I'm conscious we're getting towards 1 o'clock now. So I don't want to get onto viability now. I think we need to break. I would like the council to go back and look at figures, their figures, and at least come up with some kind of indication in terms of the figures they've got on need, and like what 50% is likely to kind of produce. So I've got some idea of that. So I'd like that piece of work to be done, please. Mrs. Parsons, did you want to come back in now?
Yeah, sorry, it was just to say that the information that I think Mr. Hobbs is going to go back and interrogate for you, it is all about the population change, but I couldn't see anything that said that population change generated a need for accessible accommodation. There is a missing piece of evidence. So even if he does go back and look at that information and provide you with that maths, it's only going to tell you in population terms. I don't believe it's going to tell you in terms of accessibility, accessible homes needs, what is required. So there still is a very big missing piece of information here. We've jumped from looking at population change to equating that to a requirement for accessible homes.
Mm. So what kind of information, kind of evidence in terms of the need for that accessibility do you think is needed?
For instance, in the SHMA, it talks about over 65s that have, hang on, let me just get the right wording, limiting long-term illnesses that limits them a lot. I'm not paraphrasing, that's actually what it says, limits them a lot, but it doesn't explain what that limitation is. My father has a long-term illness and it limits him, but it doesn't mean that he has to move out of his 3-storey house at the moment. He can still get around. There needs to be further evidence to understand what those accessibility requirements are. Because you have a limiting illness or because you get old, doesn't mean that you need accessible homes. There needs to be evidence to show that. I don't know what that evidence is, but they need to be coming up with it. And it's, quite frankly, it's not my job to find that evidence for them. It's theirs.
Yeah. Yeah, no, I understand that. Thank you.
Mum, sorry, it's Richard Brown. Sorry, I can't put my hand up, but
yeah,
this is, I think, a really important point. If you look at 13.31, it quite clearly, and as I say, I think it's more than the figures, but the council clearly set out at 13.31 that there's a need for specialist accommodation, like 755 sheltered housing, and then 73 enhanced, 176 extra care housing, and so on and so on. The response from the council about having building regs, of having adaptable dwellings, it doesn't address the need, Mum. As I say, 1331 talks about sheltered housing and enhanced sheltered housing and extra care. I'm sorry, Mum, but even if it is 50% or whatever the figure is, there's more to the provision of elderly accommodation than just making it adaptable for wheelchairs. And it seems to me, Mum, if I can urge you to press the council on this point, because I think, as I say, the plan is not sound. It's quite clear. It's clearly in conflict, and I think you should press them, Mum.
Okay.
Madam, I say I'm conscious of the time as well, but just briefly, in terms of what we are able to do and to what extent, I suspect that Ms Parsons is asking for the impossible. What you've got from the SHMAR is clearly data on the makeup of the population, and including projections as to how that population will change over the relevant life of the plan. Within those broad categories, there will be, as it were, a myriad of personal circumstances, including both the mental and physical condition of the individuals concerned, and also their, as it were, personal preferences and dispositions, which no planning system either can or should be expected to micromanage, because it's clearly not for the council to determine how people should make their life choices as they experience changes in their circumstances, whether it's through reasons of illness, ill health, or aging. But what should be ensured is that the opportunities are available for those who do, within those groups, need adaptable housing. What we will endeavour to do, because obviously it's clearly something that you've identified as important, is we will reinterrogate the SHMAR data to see whether it's possible to give any finer grained analysis from the information which is available. As I suspect that there will be some limitations to that. But we will also look at the other side of the equation in terms of the potential supply, bearing in mind, as Mr Hobbs has made the point, that in fact, albeit that the policy is referring to a 50% provision, it's a 50% provision of what is effectively a smaller and smaller pool of potential sites. That's to say the sites that don't already have a planning permission. So if we can obviously identify that, to seek to identify what that quantum is, I suspect that then what you're likely to end up with is a situation whereby simply a judgment then has to be made between what you might call the wider pool of persons who potentially may need an adaptable dwelling. And I say, going back to the fact that it's not for the planning system to micromanage what particular individuals do or don't choose to do with their life and the life choices they face, and then comparing that pool with the residual supply, and then you will, say, have to form a view as to whether the council has got it broadly right, that it considers that the 50% provision is a reasonable way of responding to that issue or not. Obviously, we will talk about viability this afternoon because that is clearly an important part of the equation. But I think there are going to be some limits in what the council is going to be able to provide you with, but we will obviously look to provide you with as much helpful information from the evidence base as we can.
Yeah, what kind of timescale is that going to be possible to look at? Because I think obviously other people will need to look at it potentially as well as me. But I mean, like, when do you think that might be possible?
Well, I'll turn to Mr Hobbs for the detail, but I suspect reinterrogating the SHMAR to see whether that can give finer grained analysis will be a relatively short task. Looking through the quantum of planning permissions compared to potential sites which are allocated but don't yet have a planning permission, that might take rather longer to verify which types are suitable for this policy provision to be applied to. But perhaps Mr. Hobbs can comment on what he's thinking in terms of timescale.
I'm anticipating he wants to come back after lunch with some more clarity on this. Is that what you're seeking?
Well, I mean, no, I wasn't expecting it that fast. I mean, if you, I was expecting more, that you would need a bit more time than that. Sure. But yeah. I mean, I'm just kind of like, you know, what I'd like to set some kind of like timescale so that people know when some information might be available, because obviously it's quite a big issue, this. Can
we come back after lunch, because I'm conscious we've got other hearings obviously tomorrow and then next week as well, so perhaps if I can come back with proposed date.
Right, yes, you can do, yeah, right. Thank you. Well, thank you very much. I know it's not an ideal place to break this in the middle of a policy, but it is 1:05 already, so we'll be back at 2 o'clock to start this afternoon session. Thank you very much.
Thank you.
And don't forget Right, it is now 2 o'clock, so we're going to resume the hearing session. Before we get back into LPO6, does the council want to come back to me with what they've considered about the timescale for that piece of work?
Apologise, madam, we do it. So my mouse had gone on a frolic of its own. I think we'd like to deal with it in, as it were, 2 parts. I think we think that we'll be able to provide you with information on the potential number of dwellings to which policy LP06 would apply in the expected supply of housing, because obviously it will only apply to sites which don't already have a planning permission. And we think that in both districts, the number of expected dwellings to which the policy will be applied will be less than half of the supply that is expected. But we'll provide the figures for that, and we would expect to be able to do that by the end of this week, if that's acceptable to you.
Yeah.
We will also look at the nature of the evidence that was submitted to the East Suffolk local plan. You'll be aware that it was the Suffolk Coastal Local Plan as such, because at the time that plan had been submitted for examination, Suffolk Coastal and Waveney Council were 2 different councils, so it's the Suffolk Coastal part of East Suffolk Council. But so far as we can see, that was a recent plan in similar circumstances, and we think it was supported by similar evidence, and it produced effectively a similar outcome in terms of the policy that was accepted by that inspector, having heard, we think, somewhat similar arguments and issues being raised. So I think we'll just include in our note something that just gives references to that, to the extent that that is helpful in terms of indicating an approach. Then in terms of the other part of the exercise, which is looking more at the composition of the population and future households, and seeing to what extent you can interrogate the data in the SHMAR further, or supplement the data in the SHMAR from other public sources of data on household composition, their needs and attributes. That may take a little bit longer, and we were hoping to be able to achieve that by the beginning of October. 7th of October is what I'm being told, and so we would provide a note which provided that. Obviously, if we can achieve that work earlier than that, we'll do so, but those were the dates that we were suggesting.
Yeah, thank you, that'd be very helpful.
Thank you, ma'am.
So if we turn to look at the kind of viability kind of questions with LPO6 now. Obviously, some of the developers have already picked up on some of the issues. I know it was Mrs. Hay who picked up, about the figure of £521 per dwelling, based on figures that were 7 years old, in terms of your viability assessment. I wonder, would you like to come back and address that, please, and tell me, in terms of how you've looked at viability, why you think those figures are appropriate?
Thank you, madam. In terms of the broad position, as you will know, the plan is supported by the Plan Viability and SIL Review study of October 2020 by Aspinall Verdi, and that document, sorry, I can give you a reference to that in a moment. Oops. Yes, ER02, I apologise.
Right.
That obviously included inputs on costs and revenue factors to support its viability appraisals. And it's apparent from Appendix 4 of that report, the residential appraisals, that those residential appraisals did include an input for the cost of complying with M42 at 50%, and also the costs of complying with M42 and M43. And those costs were inputted, and so far as M42 is concerned, the figure that was the input figure was £521 per dwelling. It's also right to say that, albeit that policy LP06 only applies to larger developments, that's to say sites of 10 or more dwellings or 5 of a hectare, actually the viability appraisal work included that cost input even to the 8-unit dwelling viability appraisal. So to that extent, it was actually more robust because a cost was included in that viability appraisal, that the policy wouldn't actually apply that cost to it. On the question of the age of the figure, clearly Aspinall Verdi, the consultants, when they undertook that work, and it was submitted in October of last year, had reached the conclusion that the evidence inputs that they were using remained fit for purpose. And that applies obviously to all of the inputs. Whilst no doubt different people may have different views on individual inputs, what we would suggest you can't do with a viability appraisal is, as it were, cherry pick an exercise and seek to quibble with one factor and say that factor is wrong and therefore needs to be changed to a different factor. Because if you do that, you're not dealing in fact with a viability appraisal. You are adjusting only one part of an overall picture. Clearly, if you were to update any figure, then you would have to update, as it were, both sides of the equation, and you'd have to look at the revenue inputs as well as at the cost inputs. And effectively, you would have to redo the viability appraisal. We don't consider that is a proportionate approach. And we don't consider that, in a sense, criticism of an individual component, but without providing a replacement viability appraisal, really tells you anything of value. And we note that none of the objectors, perhaps for understandable reasons because of the magnitude of the task, none of them has sought to put before you a comprehensive viability appraisal as opposed to criticising a particular input. So in essence, our answer is that compliance with this policy expectation was included in the viability appraisal work. It was included at a figure which was considered by those with expertise to remain fit for purpose at the time that they did the work. And that work was done last year. We don't consider that there's anything that has happened subsequently that would justify revisiting the viability appraisal across the piece. But it would only be if you revisited it across the piece that you would really have anything that you could use as a substitute for the viability appraisal, which we consider is proportionate evidence. Just reverting briefly to Mr. Stebbing's suggestion, that effectively he might be able to live with a policy which began with a preface of subject to viability X, Y, and Z. With respect, that is simply to move the crunch issue down the line to the development management stage, and that is very much a second best. It's quite clear from the MPPF expectations that viability is something that should be looked at the plan making stage, and it's only exceptionally that one should then need to revisit viability in an individual development management context. And so we wouldn't be in favour of a general approach, which I say left that issue to the development management stage effectively in every case, that the policy would only apply if there was a bespoke viability appraisal in relation to it. So I think that's probably all we need to say at this stage. Yeah, thank you, Madam.
Thank you. Would any of the developers who've raised issues like to come back on what the council have just said there in terms of viability? Mr. Stebbings?
I don't disagree with what Mr. Bedford has just put to you in terms of, I think he used the word cherry picking parts of the plan viability appraisal, and I mean he's absolutely right. It would to cherry pick one or more items would require, frankly, the whole viability appraisal to be redone, and that's no small task. That said, the evidence I have from my clients and other clients in the house building industry is that a figure of £521 to implement in full Part M4 brackets 2 of the building regulations is, in today's construction market, woefully short of what the realistic figure is. And that's all I'm going to say on that point.
Do they have any better figures?
I have heard figures quoted up to £10,000 per 2 or 3 bedroom dwelling. But I'm not going to present evidence to you because I think that if you were to accept that evidence, or even if the council were to accept that evidence, it would inevitably require a significant reappraisal of the council's viability work. But there is absolutely no doubt, Madam, that the figure of £521 is a historic figure, and whether it was regarded late last year as still being fit for purpose by the report's authors, I think even more recent events have superseded that. Thank you.
Mrs. Hay?
Thank you, Mum. And just to clarify, I'm not looking to challenge the viability study as a whole or the process. It is just the age of this figure. And indeed, I've gone back to this original cost report where the figure seems to originate. And the figure for apartments, for example, seems to be as high as £940, despite being in sort of September 2014. I appreciate what the council have come back with. I still have a couple of concerns in that regard. Thank you.
And Mrs. Payne?
Thank you. No, like those that have just gone before me, I understand that it's a difficult and challenging thing to go back and unpick a viability study. But as I put to you in my matter statement, there was data last year as part of the government's housing consultation review that did update those figures and on average suggested it was nearer to £13,000 per dwelling. Again, not looking to necessarily for things to be unpicked, but it is just to obviously put that more up-to-date figure in place, conscious that the viability study does obviously identify that the policy already has a high impact on viability for schemes. So I will just leave that with you, but the reference to where I'm talking about does sit within my math statement for number 5.
Okay. Mr. Barant.
Thank you, ma'am. Just a really quick point about actually revisiting the viability study. It doesn't necessarily require a whole revisiting of the viability study to know whether understand what the impact on the viability is. It's looking in terms of the headroom that's already existing within between the residual land value and the threshold land value or the baseline value. So I think it's important you can look at that and understand what those impacts are going to be. I suppose if we had the viability consultants here to actually discuss that matter. I think there are issues with regard to both brownfield and greenfield sites and the different levels of viability and what the advice was within the viability study that might need to be taken into account, and whether actually there needs to be a greater degree of variability and flexibility within the policies, whether it's this policy or other policies within the local plan in terms of ensuring that development does come forward. So I think there is a balance, and it is important to understand that and understand where it is in terms of the level of headroom that's within the viability and within development to take forward, and not having to necessarily re-put in all the figures in. There's usually some form of sensitivity analysis that can be undertaken, and probably has been undertaken by the viability consultants if they were here to actually debate that point. No, thank you.
Thank you. Is there anything the council want to come back on what the developers have just said?
I don't think there is anything that really sort of further helps you on the position. I think we've heard what's said, but we don't accept that really that changes the point. If you would want some form of sensitivity check from our viability consultants, subject only obviously to the timescale implications of that, we can see whether or not that's something that they can provide. But essentially, I say we think that it's not appropriate to seek to revisit and redo the viability appraisal. I don't think anybody is really suggesting that, and therefore we don't think that focusing on one particular input to the exclusion of any others really helps identify an appropriate approach.
Thank you. Well, I think I want to think about what I've heard about the viability and consider that further before making any definite decision as to whether additional work needs to be done. Is there? I've still got some other questions on our P06, but is there anything else in terms of the viability issues that people want to raise? Mr. Stebbing?
Thank you, ma'am, for letting me come in. I mean, you will have seen from our hearing statement that I've got a broader issue about the viability impacts of this particular policy, and I won't go through those now. You've got them in the hearing statement. But if you reach a view on just this specific issue that we were talking about a few minutes ago, and whether the figure of £521 is anywhere near the mark, it won't be lost on you and your fellow inspector that the overall impact on viability will not be positive. Thank you.
Mrs. Davis.
Thank you, Madam Chair. I'd just like to come back to the original wording of the policy, which I've just clicked down on my screen, so it's vanished. Sorry, let me scroll forward. Here we go, where someone else referred to earlier, 1A must accommodate 35% affordable housing and suggested it be reworded to should. In Sproughton Parish, our October 20 housing needs assessment said that affordable housing was most in demand. And we have had instances, well, one particular instance where a housing developer agreed to develop 35% of affordable housing, but subsequently delivered 20%, saying that it was not viable. It would be incredibly helpful if viability assessments were delivered at the point a planning application is submitted, so that any future changes where viability claims are changed, that particular change can be assessed. I don't think we can stress too much the need for affordable housing, certainly in Sproughton Parish and probably Suffolk as a whole, when you consider the nature of the employment opportunities here, which are not generally high grade, and the majority of people need to earn at least £25,000 a year in order to be able to just hit the afford to buy entry route into owning a home. So I would respectfully suggest that we do keep the word must in there, and we do nail down the requirement for viability assessments and any changes thereafter to be provided.
Thank you. I mean, in terms of affordable housing and that part of the policy, we are looking, my fellow inspector is actually going to be looking at affordable housing in a lot more detail under matter 3. But I mean, obviously, the word must also applies to 1B. So I take on point your comments in terms of that.
Thank you.
Mr. Stringer, you.
Thank you, Madam Chair. Just wanted to, didn't want to get too embroiled in this, but I can't help but noticing that we're arguing about, or we're discussing one input into a viability assessment, but are we taking into account recent changes in sales values, for instance? Because this is all an equation, and all of the data I've got is the last part of the equation since this document was written has significantly gone up. And, you know, the evidence of bonuses and whatnot to developers, you know, bear that out. What one company's bonus to their managing director was £6,700 per home. So there is obviously, you know, we need to be, and I don't want to unpick it all. What I just wanted to mention is, of course, our original objection to this policy was not bound by M42. It was suggesting that we should have a number that were M43, that people actually in a wheelchair could actually live in these dwellings, heaven forbid. And we base that on, I don't want to rake over too much data with you, but there is nationally government agreed data that 1.8% of our population as a country is actively using a wheelchair. There are 2. However many people per home. That equates to 4.32% in Mid-Suffolk. You take off some of that percentage for those that are in residential care homes, because I would imagine people in residential care homes are proportionately more in wheelchairs, which is why we ended up with a figure of about 3%. And I would think it incredible if the market wanted to deny 3% of a market from the ability to buy any new home. Thank you for listening, Chair.
Thank you. Yes, I'm aware of your comments that you've made in your statement as well. Lady Hart.
Thank you. I'd just like to endorse what Mrs. Davis has said about keeping must. Chiltern Parish Council would support that. Sorry, must in regard to paragraph A. our experience has recently been with a development of 1,150 houses where Suffolk County Council applied for outline planning permission and gained it. They did supply a viability assessment, but said they couldn't provide 35%, and that was the amount required under the policy. Persuaded the LPA that 22% would be would be the viable percentage. A commercial developer has bought the site now. They're only having to produce 22% affordable housing, and of that affordable housing, in discussions with them at the moment, they only consider it appropriate to provide 2 apartments which are wheelchair accessible out of 1,150 dwellings. So I think I would support the council in imposing a arithmetical position, because otherwise these suitable housing isn't going to be delivered. Thank you.
Thank you. I say obviously affordable housing will be discussed in October, but I understand what you're saying. In terms of what Mr. Stringer said about M43, does the council want to say anything in response to that?
I'll ask Mr. Hobbs if he wants to comment on that aspect.
Only that we're not making a request for M43 as part of development. We recognise the additional cost that incurs, and also we provide some M43 through our own sort of housing stock, as it were.
Mr. Stringer, your hand's up. Is that from when? Do you want to come back with something else, or was that from previously?
Sorry, Chair, historical.
Rightio, that's no problem. So obviously I need to say consider viability and go back and look at what you've been saying and consider that. But so is there anything else on viability before we move on to other bits of LPO6 that I want to raise? Right, I'd like to look at clause C of LPO6, and I'd like to ask the council, because it refers to the most relevant district needs assessment that's supported by the council, and I just want to know how will they know what that document is, because it seems, you know, it's not very clear what that's going to be, what you will consider the most relevant that you support.
Well, thank you, Madam. That's one of those issues where we haven't referred to a specific document because we recognise that obviously the plan is intended to be in place over its planned period. And the particular document at the moment, which is part of the SHMAR, will not necessarily be the most up-to-date or relevant document during the life of the plan. So that's why we've used a form of words to, as it were, capture not only that document, but also what might be more up-to-date documents in due course. I think if it's too cryptic as to how it's currently worded, we could certainly add a footnote to identify that currently that's the SHMAR, but it would be any document that similarly replaced that. Obviously, as you will be aware, because of the changes in planning practice guidance and the NPPF, since the SHMAR was carried out, there may not be, as it were, a need to specifically commission a document that would be a SHMAR as such. It may be a different type of housing needs assessment document that the council would produce. But that's in a sense why it's worded as it is. But as I say, we could certainly add a footnote if that would help clarify what it currently is, and obviously we'd then take into account at the time that any application was being considered whether that had been superseded by more recent statistical documentation.
Yeah, and I think that would be helpful, because I think it's just, especially where it says it's the most relevant, and that the council support, and that it may be that, like, you know, I don't know, there's a sense that there might be kind of a more recent document that you decide you don't support that, and like, I think, you know, there's a bit potential for confusion there. So I think we need to clarify that, to, you know, that if it's like the most recent kind of housing needs assessment, you know, which is currently this SMAR, but or whatever will replace it. I think that would be helpful if you could a footnote to clarify that, so that people are clear, and that it's not that the council can almost cherry pick which document they think that they're going to support. Mr. Stebbing, did you want to come in on that point? You're on mute still.
Apologies for that. I don't know whether you're going to accept Mr. Bedford's proposition to you as the final statement on this, but I'm afraid I don't think it goes nearly far enough. And firstly, I've got an issue with the supporting justification for whatever the council's preferred housing mix is likely to be, and bearing in mind that this is the housing mix policy. In my experience, it should be indicating that it seeks, in broad terms, a mix of however many percentage points of 2, 3, and 4 bedroom dwellings, or 1 bedroom dwellings for that matter. At least in the justification, acknowledging that that may change over time. It doesn't do this, and paragraphs 13, 25 and 26 are the nearest we get to an explanation of what a preferred housing mix will be on these larger sites, Mum. So I think a simple footnote saying that this document or that document might be in due course replaced is fine, but it doesn't go far enough. Thank you.
Thank you. Does the council want to come back on that comment?
I think, Madam, we were content that expecting a proposal to reflect the mix and type of housing shown by the relevant housing needs document, whatever it may be, provided sufficient clarity but also flexibility. Obviously, if you were to write in to the plan specific percentages, you are, as it were, crystallising it to the evidence as it currently stands. And given that the document that you would refer to is not intended to be the SMAR and only the SMAR for the life of the plan, and necessarily the percentages might change over the life of the plan, we think it would be inflexible and at risk of, in a sense, becoming out of date if we were to specify particular percentages at this stage. It's effectively it's a living document that's being referred to, and therefore it's appropriate to have a generic reference rather than a specific reference. You could add in the supporting text what the current percentages are, but that might tend to confuse rather than it would help.
Mr. Birant.
Thank you, Mum. it's really with regard to, I suppose, what Mr. Bedford has just said in terms of the SHMA is in effect very much a snapshot in time. It is at that point. It's not necessarily going to, it will change and needs will change over time. I think one of the important things, I think, therefore, is to reflect within that any additional monitoring report and evidence that comes forward should be a part of that consideration in terms of needs, and what has been delivered in the past will shape what is delivered over the entirety of the area. So I think it's important to recognise it is a snapshot in time. And I think with regard to that snapshot in time, rather than reflect that evidence in terms of actually, mirror it in a sense, is actually development should have regard to what it says. So it is a far more flexible policy, as Mr. Bedford was alluding to. And I think by having regard to that evidence, then actually there can be more flexibility within that to ensure that the needs at that specific point in time, depending on the variety of evidence that might be available, is there. So I think that there's certain slight wordings there to make it sufficiently flexible to recognise that it is a snapshot in time and actually will change and could change quite considerably over time. Thank you, Mark.
Lady Hart.
Thank you, Madam. Just if perhaps I could raise what I have seen in my practical experience happens in development management terms if there isn't a provision, as the council have put, referring to some sort of document. I think there does need to be something, whether it's percentage or a clearer reference to a document, because what happens now is that when a major site comes forward for planning permission, it's heavily weighted generally for 4 to 5 bedroom houses. The strategic housing manager will quite often put in a response to the residential application saying they need some bungalows and they need 1 or 2 bedroom needs apartments and smaller housing, and the parishes generally support that because of the ageing demographic. And then what happens is we are told at the planning meeting that the planning officers can't support that because there's no provision in the local plan and they can't put a condition in to that effect. So I think in practical terms, I'd support the council to have a provision of some sort that requires a mix. Thank you.
Thank you. Mr. Short.
Thank you. It's sort of slightly different slant I'll take on Lady Hart's comments of just now, and speaking as somebody who regularly submits application for above 10 dwellings in both Baber and Mid Suffolk, I can tell you that the prescriptive response from the strategic housing manager in terms of market housing is just that. It is incredibly prescriptive. The same applies to the affordable housing. When they make reference to evidence to support their position, they do make reference to the SHMA. Now, unless I've missed them, I don't see the SHMA being produced or updated every year. So I don't see the difficulty in taking what's in the current SHMA, representing its housing mix requirement in the form of a table, and the subsequent SHMA. I mean, how many SHMAs will there be before the whole plan is up for review? We're only talking about the next 5 years anyway. I think the industry would prefer something that is a bit more prescriptive, even though the policy wording can be generalised or should pay regard to the mix, as it has been in adjacent authorities for the past 5 years, and for it still to give a sense of direction, particularly when developers are acquiring sites either under option or they're purchasing and there's no form of planning permission. An indication of what they can put on there is extremely helpful. The strategic housing manager, of course, goes on a stage further in terms of the affordable housing and makes reference to a 10-year split. I'm veering off into areas that are subsequently to be discussed. but the tenure split there too is the subject of argument which has lasted in some cases 12 months and delayed development. The absence of detail, both in terms of housing mix and the tenure affordable which is acceptable, is something that I think the industry would welcome. Thank you.
Right. Well, I think the council. You've accepted that there probably needs to be. You need to look at the wording. So can you? I'd like you to do that and come back to me. You've heard the kind of comments, and come back with a kind of form of wording that I can consider. Please on that to kind of maybe tighten up what is said there.
Certainly, Madam, and we will look at, in the light of Mr. Short's comments, as to whether, in fact, the development sector would find it more helpful to give further guidance as to what the expectations are, almost as it were taking the price of that is that there's a greater risk of it becoming out of date because of if it's tied to what we currently know from the SHMA. But if that is thought to be more helpful in terms of providing greater certainty, that's certainly something we'll reflect on to see whether that would be sort of assistance. So yes, we'll take that away.
Yeah, thank you. Mrs. Payne, you want to come in?
Thank you. Just briefly, yes, just listening to that debate there as well. I think from my experience and with my clients as well, it's the flexibility, I think, that the policy currently, as it is currently drafted, is welcomed. A scheme needs to be able to respond to what the market demand is and what the local need is. And I think the fact of, as been described by the council in terms of looking at the mix and type and not trying to pin that down to what the current SHMA says, which quite rightly will go out of date very quickly, is the right approach, and to be more clear as to what that district needs assessment would be that they would support. And also I would add to that the ability for consideration of market evidence to be put forward to supplement that information. Things move forward as HBF have said as well, it is a point in time, the SHMA, so would certainly welcome the flexibility. I think COVID's a perfect example of it as well. Things change, things move on, so looking at that flexibility would be welcomed. Thank you.
Thank you. Mr. Short?
Thank you. It's just a brief point. I noticed that the current drafting of paragraph C in this particular sentence refers to the most relevant district needs assessment, and yet we've got 13.36, I think it is, refers to neighbourhood plans coming forward with the sub-district needs assessment. I just wondered whether it might be worth including some flexibility within the policy that not only refers to sub-district, but if there's any other needs assessment produced which might be more specific to a parish or a particular area, even if that is produced by an applicant.
Thank you. So I'll get the council to kind of to consider the points that have been put forward, and come back to me with a set of wording that they think may provide a bit more clarity, but with some flexibility as well to be able to just look at that, and then I'll consider those points further. What I also wanted to know is how Part C relates to Part 3 of LP07, because obviously that then talks about neighbourhood plans being able to set out approach. So I mean, that's a bit like Mr. Short's just mentioned. How do those two parts relate. And I did wonder whether that part 3 in LPO 7 is really more appropriate in LPO 6 than
Okay. Yeah, we'll consider. I see where you're coming from.
yeah, because I mean obviously that's talking about mixing the neighbourhood plans and like so I think it might be better in LPO 6. So maybe you could consider that at the same time when you're looking at the wider issues that we've talked about.
Okay.
Mr. Stebbing?
Well, the point you've just made, Madam, is exactly a point I was going to come on to make with the remainder of LPO 6. I mean, there is some crossover between LPO 6 and LPO 7. And while I've got the floor, I'm not certain that this potential district-wide Article 4 direction, which is what it amounts to on bungalows, the removal of PD rights, is actually necessary under LPO 6, although I can more understand the reasoning for it in LPO 7, where it appears as well. That's so. Just
yeah, well, I want to ask. I'm going to bring
Yeah.
up the bungalows in a minute. So
and very, very finally, probably none of this that we're now talking about is frankly described in the justification for the policy. And I get you will have gathered I've got as many concerns over the justification as I have on the policy itself. Thank you.
Thank you. Mr. Clow?
Thank you. Just following up on the point on moving section 3 of LPO 7 to LPO 6. Understand the reasoning you've set out there, but I just wanted to make it known that the County Council would support neighbourhood plans being able to allocate sites for special needs and supported housing where there is appropriate evidence to support it. Thank you.
Yeah. Yeah, well, I mean, we'll come on to discuss that obviously a bit more when we get on to LPO 7 as well. But just if we move on to the issue that Mr. Stebbings just raised a bit about the bungalows in part C as well. I mean, can I understand? I mean, as it's written, it seems to remove all permitted development rights from bungalows, and is that what it's intended? I mean, like, should ground floor extensions be the potential to do ground floor extensions be removed from a bungalow?
No, that's. I think the intention is that it should be it should remain in perpetuity as a bungalow, rather than that it should remain in perpetuity exactly as it was originally built. So if the language isn't clear enough to make that clear, then we perhaps need to look at that. But the intention was that if you're providing effectively single floor accommodation for those who prefer single floor accommodation, i.e. without stairs, then the provision of housing to meet that particular need in the market is something that should then be retained so that that need continues to be met. So that's what we were aiming to get at with those words, rather than, I say, removing the ability to put up, as you say, ground floor extensions, or indeed other ground floor type activities, or indeed swimming pools, I suppose, for that matter, if that was something that somebody wanted to do. Right,
yeah. Well, maybe we just need to clarify that it's not all PD rights would be removed from bungalows. Does the in the two councils, is there a history of bungalows being converted to houses once, you know, if they're built? Is it, you know, is there a clear evidence that that is often happening?
Perhaps a matter more for Mr. Hobbs.
Thank you, man. Yeah, that's certainly a concern, and through consultation that we've undertaken on the local plan, as well as responses to consultations through planning applications, there's strong local demand for bungalows, yeah, there's definitely a concern about the potential for them to turn into houses, but I couldn't give you the sort of figures off the top of my head. But if you want us to look further on that, maybe we could.
Yeah, I mean, obviously, it's just, I mean, I'm conscious that the MPPF in paragraph 54 says that there needs to be clear justification for removal of permitted development rights. So that's why I was wondering, like, you know, as I say, if there's been a history of, like, you know, I understand the need and the desire to provide bungalows and that, you know, that they are a form of housing that is often very popular. But I just wanted to say whether there has been, in terms of that clear justification, if there has been a history of this being a particular problem in terms of them being converted into houses and then losing that bungalow. So if that is something you could look at for me and get back to me, that would help me understand the justification.
Okay.
I think that's all I have to say about LPO6 and all the kind of things I needed to find out. Is there anything else anyone wants to say on LPO6 before we move on? Right. Well, we'll move on to LPO7, which is obviously quite related to LPO6. And in terms of it, I mean, obviously this is for supported and special needs housing, and I mean, obviously your evidence indicates a significant need for kind of this specialist housing, and I wondered how confident you are that the policy will be able to meet this need without allocating any particular sites for it. Because I'm conscious that often in the providing sites for that, you know, developers can often, who want to provide that kind of specialist housing, can often get outbid. So I just wondered, like, in terms of, you know, without allocating sites, are you confident that this policy is going to provide what you need?
If perhaps I start and then again, Mr. Hobbs adds further comments. As a basic approach, we've taken the view that where housing in terms of supported or special needs housing is being delivered by the market, then it's effectively for the market to address the costs of provision, including any land acquisition costs. And in a sense, we don't consider that this particular form of housing is one that the market has shown itself to be incapable of providing, in a sense of market failure, which might justify then a special policy treatment to enable this type of housing to be provided. So that's our kind of starting point. Then the second point is, as criterion A of the policy makes it clear, sites that would be supported are sites which are appropriate for residential development. And that effectively necessarily means that they are appropriate for all types of residential development. Now, as a a generality, and there will always be special cases that somebody can point to that's an exception to the generality. But as a generality, a site which is suitable to providing supported or special needs housing will also, in land use terms and in spatial planning terms and in urban design terms, be suitable for providing other types of market housing, or indeed housing full stop. And it's difficult to be able to identify a rationale which says, in relation to a particular parcel of land, there is a land use reason why that site is suitable for housing, but it is only suitable for a particular form of housing, that's to say supported or special needs housing, and it would be objectionable in planning terms for that site to be developed for any other type of housing. And so I say we have generally taken the approach that if it's suitable for housing, it's suitable for all types of housing, and that the market is sort of capable of delivering on the needs within that policy framework. So that's why we haven't gone down the allocations route of trying to ring fence particular sites and saying to whoever are the owners or developers of those sites, in a sense, never mind what you think about what your site is suitable for. We are telling you that you are only going to be allowed to bring forward a particular type of housing on that site. So that's the kind of the underlying rationale. As to, I think your point is really effectiveness in terms of soundness issues, is to, well, if you take that approach, what is it that leads you to consider that that will be effective to deliver on the need that you've identified? And that's probably more a matter where Mr. Hobbs can explain in terms of the overall pool of sites, why he is, as it were, content that there's sufficient choice within that overall pool of sites to enable the need to be met.
Okay, thank you. Just following on from that point, as you'll be aware, Madam Chair, we've got a number of sites identified for housing across the two districts. There's a very wide geographical area, albeit we've got a settlement hierarchy, there. But yeah, what we've tried to do here is sort of provide that flexibility, so we're not singling out one particular site for this particular use. And what we see is the market, as Mr. F has alluded to, the market does deliver on this, and we've also ourselves, as a council, build this type of use. So there are outlets there for providing this to meet the needs identified across the plan period.
Mr. Brown, you'd like to come in?
Yes, thank you, Ma'am. I'm taking a very different view to Mr. Bedford and Mr. Hobbs. Could I just, Ma'am, and I think this is an important point, I think it's a fundamental point where I think they're wrong. Can I just ask that you look at paragraph 60, Ma'am, of the framework? And can I just read out the
Yeah, we've got that.
Paragraph 60 is just line 2, really. It is important that a sufficient amount and variety of land can come forward where it is needed, that the needs of groups with specific housing requirements are addressed. I think for me, Ma'am, that's quite clear. And if I could also just take you down to paragraph 62, which says that within this context, the size, type and tenure of housing needed for different groups in the community should be assessed and reflected in planning policies. It seems to me quite clear, Ma'am, that there is a need to plan positively. I say to not leave it to the development management process. That there is a need for specialised retirement accommodation and care homes, that they are enjoined. As I say, the council's response is really to make a percentage of houses on developments compliant with building regulations. It's my view that this is actually not providing specialist retirement accommodation. Mr. Hobbs also makes the point that the market will be deliver. I would have to challenge him on that, ma'am. I have not seen any evidence, and it would appear contrary, ma'am, to paragraph 13.31. It seems to me, as I say, that we have there is a requirement under the framework to plan positively. I say to not leave it to the development management process, and that's why, in my opinion, sites should be allocated. Ma'am, can I also just mention one other thing? Mr. Bedford mentioned earlier about the what was the Suffolk Coastal or East Suffolk Council local plan. I've got the benefit of looking at the inspector's report, which was the 8th of September, into that local plan. Ma'am, it's actually on. It's actually paragraph 75. So Mr. Bedford mentioned it earlier, but paragraph 75 of the inspector's report of 8th of September 2020. This is what the government inspector said. The plan as submitted would not be effective in meeting the housing needs for older and disabled people, in that it does not demonstrate that the needs of older and disabled people have been assessed, nor are these needs adequately reflected in the policies. And the only way to do that, ma'am, is if sites for care homes and retirement accommodation are allocated in the plan. I don't believe, as Mr. Hobbs suggested, that it can be left to the market. I just don't see how that's possible, ma'am, because house builders, they want to build residential homes. It's not a criticism of house builders, but they're just, it's not part of what they do. I haven't taken part in the viability argument, but yes, I've obviously heard the viability. We have a system that we have house builders, we have house types. It is very difficult for house builders to accommodate such significant percentages of properties that are subject to M4(2). Thank you.
Thank you. And Mr. Hobbs, could you come back on that? You know, obviously Mr. Brown's kind of saying the market isn't delivering. I mean, do you have evidence of how much has been provided in recent years of this kind of specialist accommodation?
Yeah, so I was going to come back to with that sounds like what we'll need to provide to you is evidence of where it's been provided and who by.
Yeah, if that would be possible, that would be very helpful.
And Madam, could I just add, by way of reference in terms of the policy position, Mr. Brown referred to paragraph 60 and 62 of the MPPF in terms of requiring matters to be addressed and matters to be assessed. That's absolutely right. But the NPPF is not prescriptive about the way in which matters are addressed or assessed. It leaves that to local decision making. And the PPG reinforces that in ID 63, which the phraseology of the PPG is to pose those rhetorical questions. And the question is, do plans need to allocate sites for specialist housing for older people? Well, if Mr. Brown was correct in his policy approach, that would get a short one-word answer, which would be yes, but it doesn't. What paragraph ID 63 013 2019 06 26 says is it is up to the plan-making body to decide whether to allocate sites for specialist housing for older people. Allocating sites can provide greater certainty for developers and encourage the provision of sites in suitable locations. This may be appropriate where there is an identified unmet need for specialist housing. So, in other words, it makes it clear that it's a matter for the local authority to decide, having regard to their circumstances. It's not a matter of national prescription. And we absolutely accept the point that if you do allocate, you provide more certainty. But with respect, what Mr. Brown didn't attempt to address was the spatial or land use justifications that would, as it were, justify a local authority saying in relation to a particular parcel of land, this land is suitable for residential development in spatial planning, urban design and land use terms, but we're not going to allow that to happen. We are going to ring fence it so that it can only provide a specialist type of housing provision. And effectively, we would refuse planning applications for anything else because of that allocation. And so that's the conundrum which we haven't seen responded to. And so that's our position. But I say Mr. Hobbs will go on, obviously, to look at delivery on the ground, so as to hopefully provide you with some further information as to whether that approach is likely to be an effective approach in this plan area.
Thank you. Mr. Brown, you want to come back?
Yes, thank you. Thank you, Mum. Just in the context of plan making, Mum, as we're aware, paragraph 35 is very clear. It says that obviously the plans need to be positively prepared. The wording is providing a strategy which is a minimum seeks to meet the area's objectively assessed needs. What I would say, Ma'am, is that the evidence which has been produced by the council, and I am referring again to 13.31, I would be very interested to see Mr. Hobbs's confirmation. Certainly the trends of the provision of retirement, specialist retirement accommodation, it is difficult to understand the council's position that they're going to leave it to the market when there is such an acute need for retirement accommodation and care homes as set out in 13.31. That's the position which, to be fair to the council, they accept. It is an acute need. It is an acute need for significant numbers. And the question, Ma'am, that you as the inspector will need to ask yourself, I would say, relates to paragraph 35. about whether this is going to be a plan that's positively prepared and providing a strategy which, as a minimum, seeks to meet the area's objectively assessed needs. And quite clearly, that's not happening. And I would say it won't happen if this plan is published. Thank you.
Thank you. Mrs. Payne, you want to come in as well?
Thank you. I was just listening to that debate. It's interesting, and I think obviously, yes, as Mr. Brown's pointed out, there is that acute need. It's set out in the supporting justification to the policy, and I suppose just looking at it objectively slightly, if the council are looking to not allocate and they want to maintain the flexibility to the policy in terms of finding the right sites for this specialist accommodation, which I would support, then actually criteria like A is restricting it further. And I would ask whether actually specifying that it will only be considered on sites appropriate for residential development is justified as part of the policy. Are there not instances where actually it may be possible to bring forward on sites that aren't appropriate for residential development? And also, I suppose, the fact that obviously these types of schemes and the variety of products that are within specialist and supported housing do require very site-specific requirements for the additional services and facilities they have, recreational space, parking, servicing, all of that goes with it, and whether actually that can be met within the settlement boundaries of the settlement hierarchy and the tiers of the settlement hierarchy that the council has specified. And actually, is it worth them also looking to these sites adjacent to settlement boundaries where there is good connectivity, where residents can reach the local services and facilities, including health, or that a scheme could make provision to ensure that they can get to those services and facilities, and almost look at that in terms of a part of the policy that is an exception, providing that the relevant needs information is identified, that a appraisal is shown to show there aren't sites within the settlement boundary. I think it's still quite a prescriptive policy in that respect. And if the council go down the route they are looking for and want to deliver this acute need, then maybe further flexibility could be incorporated into the policy. Thank you.
Thanks. So almost a kind of sequential approach you might be suggesting there, in terms of like you've looked everywhere else and you can't, there's nothing, so that kind of approach.
Yes, yes, all right.
Mr. Clow?
Understanding what Ms. Payne has said, I would just like to emphasise that, you know, these sites will still be residences, and I wouldn't want to open up the criteria too broadly to put this type of development, so supported and special needs housing, in areas that may be too isolating for those kind of developments. At the County Council, we're very keen that these types of developments can be integrated into the local community. And so our view is that they should be on sites that are appropriate for residential development.
Thank you. Lady Hart?
I was going to make the same point as Mr. Payne. As Cameron speaking for the County Council, I disagree with Ms. Payne that A should be removed. I think it's important that these sites are suitable for residential development, Otherwise, I think I would have a concern that they might be put on sites that were less suitable, and you might have a situation arising of substandard suitable sites being offered for this sort of accommodation when they're the people who need the most accessible sites. Thank you.
Thank you. Mrs. Payne, you want to come back on that?
Sorry, just ever so briefly, I completely agree with what Lady Hart and Mr. Clow has said. And what I did say was to make sure that where those opportunities do arise, that they would still be incorporated within neighbourhoods. It's incredibly important to make sure that these residents aren't isolated. And I'm sure there are examples where the suggested sequential approach could work and they could still be part of a community and still access what they need via foot and other means. So it was just to reiterate, I'm not suggesting they're isolated in any way. I'm very much on board in terms of what they're suggesting, that they need to be part of a community as well. And I'm sure there are sites there that can do that as well.
Yeah. Right, well, I think it'd be helpful, as I say, if the council could provide information on what's been provided to date, to give me a clear indication of what the market is providing in terms of this specialist and supported housing needs. And then I can go away and consider what people have been saying about the wider issues using that information. Now, I'd like to go on to in terms of criteria 1B, the council have suggested a main modification just to pick up the terminology in terms of the settlement hierarchy, so that it reflects that terminology. I think that is needed, so I support that. Is there any comments from people on that kind of suggested main modification? Mr. Brown, you've got your you want to come in? You're still on mute, Mr. Brown.
Yeah, sorry, Ma'am. No, sorry, it was actually a point with regard to the just the evidence, Ma'am. I appreciate you've asked Mr. Hobbs, because obviously the council's position appears to be that the market is delivering. Would we have the opportunity to see that and comment? Because we're also, for example, on one or two other matters, but we're looking at the very same point. Is there any mechanism that the evidence can be made available so that we're able to comment on it, Ma'am? It seems it's a very important point, in my opinion.
Yeah, I mean, the evidence, I mean, obviously it will be anything sent in to me will be put on the examination website.
Right.
And I'll look at it. If I consider that it's necessary, I will allow people to make comments on it. Otherwise, obviously, if I make main modifications, they will be consulted on, and people will have an opportunity to respond to it there as well.
Okay, Mum, I appreciate that. And just you were obviously looking, weren't you, at B? I assume that your point is that this is presumably relating to sites within urban areas.
Yeah, it's the terminology that I think that 1B doesn't reflect the terminology of the settlement hierarchy. So the council's suggested main modification then picks that up, so it uses the terminology of the settlement hierarchy.
I understand that, Ma'am, but as I say, I appreciate you may perhaps say it's the same point, but if you're talking about sites within urban areas, it just seems to me that they're going to come forward as residential sites. They're not in my experience, going to come forward responding to specialist retirement accommodation. I understand the point about the settlement hierarchy. I don't think that has too much relevance to the responding to this need.
Yeah, but it says it's core villages as well, isn't it? It's not just the urban area. Is that what you?
No, I understand that, but Ma'am, what we're talking about here, that this plan is prefaced on the basis that in general terms, develop. I'm not talking about hamlets and whatever that were debated earlier, but generally the principle of development is obviously accepted within urban areas. I think it's more the question is that why or how are these sites, for example, within an urban area that would be consented for residential? Why would a developer want to bring it forward? Because as you heard, you know, there's other facilities and so on that need to be provided. I'm working on several care home and assisted living schemes, and there's lots that's required. It can be cafes, it can be bowling greens and things like that. That's my, you know, as I say, I accept that if it is within an urban area, yes, the principle of development is accepted. What I can't see is how that translates into the delivery of care homes and specialist accommodation.
The council, do you want to come back on that point for Mr. Brown?
Well, only briefly, Madam. I think we are essentially going around the same point, just with slightly different emphasis. The PPG that I had referred to does deal with the location of housing as a key consideration for older people who may be considering whether to move. And factors to consider include the proximity of sites to good public transport, local amenities, health services and town centres. That's the same paragraphs ID 63013. There's no suggestion in the PPG that sites for specialist need housing are seen as appropriate in non-urban locations, i.e. in the countryside. And in a sense, this is also Miss Payne's point, where she was arguing for effectively a quasi-sequential test. Obviously, there are circumstances where rural exception schemes can come forward to meet particular rural needs, but national policy doesn't identify meeting specialist housing needs for the general population in that category. The PPG certainly doesn't. It focuses very much on urban locations. And we don't see, in the absence of effectively evidence of market failure, that's to say evidence that the market has not been able to deliver, whether it's sheltered housing, extra care housing, or other forms of specialised housing, we don't see it as appropriate to take land which would not be suitable for ordinary residential development and earmark that for this type of housing development. We consider that this type of housing development should come forward on sites which are allocated and identified as suitable for housing development. Obviously, we'll look again at the figures in terms of what provision has come forward in the past, and obviously we will also look at how that relates to the overall supply of housing. And you'll obviously bear in mind, we're not talking about it in detail today, there is a considerable buffer in the supply between the sites that are identified and what is required to meet the residual housing need. So there is, we think, adequate opportunity for those who are interested in delivering specialised types of housing to find sites within the plan area in order to address that need without sacrificing land that would not be suitable for housing development for that purpose.
Mrs. Payne, you want to?
Thank you. Just a question, I suppose, to the council via you, Mum, if I may. In terms of the changes to the wording of criterion B, it was just a question as to why the Ipswich Fringe wasn't referenced in there. I appreciate, obviously, it talks about the market towns and urban areas and core villages as per the settlement hierarchy. But the Ipswich Fringe as the highest tier there doesn't appear yet. Obviously, within SPO3, it does set out that the Ipswich Fringe settlement will act as a focus for development along with, obviously, the market towns, urban areas and core villages. So it was just a question around that, really.
Mr. Hobbs, would you like to, can you respond to that question?
Well, the Ipswich Fringe is made up of different settlements within the settlement hierarchy in itself in any case.
If I may, Mum, come back.
Yes. Yeah.
But there are also settlements within the Ipswich Fringe that fall into the hinterland villages, for example, but they are still seen as sustainable locations. So it was just really that question as to, there are some settlements in the Ipswich Fringe seen as sustainable, but they're hinterland villages, and therefore, with the changes to the wording proposed, they actually wouldn't be considered for this type of development, which wouldn't seem to sit right with SPO3.
How do you respond to that, Mr. Hobbs?
Okay, something we can consider then.
Right. Well, if you can look at that and just consider that, yeah, because other people have suggested that some of the hinterland villages do have medical facilities and public transport. So it could be, if they're in the Ipswich Fringe, certainly they could be suitable locations, couldn't they? So if you look at that, I'm conscious that we're closely approaching 3:30, and I said we would, the sessions would be about 90 minutes. How do we haven't finished, we've still got a little bit more on LP07 to do, and we've also got LP11 to do. Would people, I was going to suggest we have a break now. I know I'll just I'll let Mr. Brown just speak, and then we'll potentially go for a break. But if people are happy, we can come back and just finish off these last two, the last bit of LP07 and LP11 today, rather than having to carry it over to another session. Mr. Brown, did you want to come back in, or was that?
Sorry, I was mistaken again. I'm actually finished, Ma'am. Thank you.
Right, thank you.
Thank you.
So if we break now, and potentially come back at 4 o'clock then, and just finish off the last bit of this in LP11 today, rather than doing it. Yeah, maybe. I mean, are people happy if we just make it a 15-minute break and come back at 3:45?
That's absolutely what I was going to suggest, Madam.
Right, well, we'll make it 3:45 then, and then hopefully we can get it finished off relatively quickly. Thank you very much.
Thank you, Ma'am.
Right, it is 15:45 now, so I'd like to resume again. I'd like to look at criterion 1H of policy LP07 now. And I'd just like to ask the council about this, and particularly given that this policy deals with proposals for specialist housing, I want to kind of ask whether requiring M402 is appropriate, because will they not be designed according to the level of care to be provided? And then is there a potential that M42 may well not be appropriate for some of those kind of specialist housing needs? So I'd like the council's view on that, please.
Thank you. Yeah, we wrote into the policy as sort of 100% of the supported or special needs housing requiring to be accessible and adaptable, given the type of people that would be using this type of dwelling. But taking your point and the conversation that's gone before, maybe we do need to just consider whether M42 is appropriate, or whether or what standards they are being built to as at present.
Right, so that's something you'll have a look at. Yep. Yeah, because I say, I mean, it probably is appropriate for quite a lot of it, but may not be appropriate for some. Mr. Clow, you want to come in on that?
Yes, I just wanted to say that you'll know from our hearing statement that we supported that it should be 100% M42 for the supported and special needs housing. That the adaptability element is quite important, because different people going into these facilities or types of housing are going to have different needs. So that ability to change the dwelling to their needs is very important. But there's a point that some of the requirement they may actually require, depending on certain very severe or complex needs, may potentially need higher standards. So I would suggest perhaps if the council are looking at altering that requirement, that maybe suggest that M42 is a minimum.
Right, yeah. But is there not potentially any circumstances in some of that housing where M42 might not be required? Different people might different specialists need accommodation that might not need M42, or do you see it that everything that would be provided under that does? I mean, in terms of people with, say maybe with kind of more learning difficulties or something like that,
potentially, but I think that having that adaptability is key. Even people with learning disabilities, for example, I've got members of my family with autism. They may have specific space needs, so I think having that adaptability there in the supported and specialist housing is very important.
Mr. Stebbing, you want to come in?
Thank you, Mum. This is one instance where I'm actually supporting the council's policy wording. I think it is appropriate here, particularly as the policy does include the potential for extensions and conversions, presumably of existing buildings. Thank you.
Is there anyone else who wants to say anything on that in terms of 1H and whether that's appropriate or not? Or
I think, Madam, in the light of what we've been hearing, particularly from the County Council, what we need to do, we've said we'll take it away and look at it, is we need to have a clear understanding that, in a sense, that nothing in M42 would effectively operate to exclude types of supported or special needs housing, so that it can fairly then operate as a floor FLOOR to provision, and in a sense, anything further is building on that floor. But I say, I'm afraid we're not probably as au fait with all of the minutiae of M42 as perhaps we ought to be. So I think we probably just need to check that to make sure, I say, that we're not doing things. And if necessary, it could be that the policy could be, that criterion H could be refined by where appropriate meets the requirement for, so as to allow for the fact that if there was some particular types of special needs housing for which that type of provision wouldn't be appropriate, that we're not shutting the door to that coming forward through the policy. But if say we'll take it away and look at it, and obviously look at that in the context of what the requirements of M42 would mean for different types of accommodation.
That would be very helpful, thank you. Obviously, part 2 of this policy looks at permitted development rights for bungalows again, which we've discussed under LP6. So I don't particularly want to go back there, but it will reflect on that as well. Because I think the council were going to go away and do some extra work on just look at that, and whether it's been whether bungalows to houses has been a particular issue, and refine the wording to reflect that it's not all permitted development rights. It's would be excluded. So is there anything else on LP07 that anyone wants to raise? No, then we can move on to LP11, which is the last policy for the day. Which is to do with self-build and custom build housing. And my first question really to the council is, obviously your evidence states that there's a need for 105 permissions a year over the 2 districts to meet the kind of demand for self-build and custom build housing. Why do you consider that this policy will be sufficient to meet that identified need? And again, what kind of has been achieved to date in terms of permission granted per annum?
So perhaps if Mr. Hobbs starts on the position on the ground, and then I'll make some more general comments when he's finished.
Thank you. Yeah, we have a lot of self-build gets delivered in the 2 districts, and that's monitored through the community infrastructure levy. For example, the amount of exemptions we grant, so we can provide, additional figures on up to date on what's come through the system if you require that, Madam Chair. In terms of permissions, there are some schemes that come forward with an element of self-build on them, not a huge amount, but like we say, it's usually the single dwelling sites or very small sites that come through that make up quite a lot of the supply through the windfall allowance.
So when you say some schemes, do you mean some of the larger schemes do come forward with an element of some self-build allowed on it, or
a few have been given permission not too long ago with an element of self-build in the permission.
Right, yeah. But it's mainly the kind of more individual sites.
Yep.
And Madam, the general point I would just make, it links back to what I was saying earlier. If you were to specifically identify sites and ring fence them for self-build or custom build, there needs to be a planning rationale for that as to why that development site is only suitable for that form of housing provision rather than for other forms of housing provision. And say our experience has been that such sites do come forward, and self-builders effectively they choose their locations and we're not entirely sure that we're the best people to choose the locations for them in the context of saying, well, there is a pool of sites which are suitable for residential development, and thereafter they, along with others in the market, will decide where it's appropriate for them to make provision.
Yeah, well, I would appreciate it if you could provide a list to give me an indication of what's been provided in recent years. So I've got an indication of how much that's coming through in terms of like the supply that you need to provide. Mrs. Payne, I think you've you on behalf of Pigeon have suggested a potential wording to change this. So could you explain why you think this is necessary and why it would be more effective than what's being suggested?
Yep, certainly. Thank you. Well, I think just to start, certainly support the council's approach to this. And just as Mr. Bedford said, I think it's a case that it's really positive to not have a prescribed percentage of plots to be delivered on large schemes, because it is indeed Pigeon's experience that self-builders like to choose where they want to live, and therefore they come forward with the sites as and when they can acquire them. And I suppose to that end, that there is a bit of a question as to how those on the register at the moment, because I believe they have to identify sort of locational requirements and their site requirements, and how that's been taken into account as part of the wording of this policy. Because again, as I mentioned in LPO1, a lot of self-builders like to keep within their existing communities, don't necessarily want to go a huge distance from where they've built up connections, and therefore it's the availability of plots within settlement boundaries. Again, is there actually the ability to look at adjacent land in order to deliver that for them as well? And to that end, yes, within our Reg 19 reps, we did make a suggestion there. She says, going through her paperwork quickly. I'm sorry, 2 seconds. So it was suggestion there that using the criteria from LPO1, that could be brought forward into this policy as a criteria-based approach to look at sites that are adjacent to the settlement boundaries as well, and give that additional opportunity to deliver these sites for self-build and custom build owners. And then there was a second suggestion there, in order to remove the ambiguity that we feel that there is in point 1 of the policy, is to remove the word appropriate, because at the moment it does suggest that it will only be permissible on appropriate sites, which brings planning judgment into that. And again, I don't think that is particularly clear to applicants and self-builders coming forward with sites. So the suggestion is to remove the word appropriate. Thank you.
Thank you. Has the council got any response they'd like to make to that?
I think in terms of the word appropriate, I think the issue there was because paragraph subclause 1 is not intending to require every site that may come forward for development of any scale to necessarily include a proportion of service dwelling plots for self-build. So the word appropriate there was, I think, intended to suggest that, for example, a relatively small site might not be expected to be suitable candidate for that if it was being promoted for what you might say is ordinary market housing. If you remove the word appropriate, I think you'd actually have to look at the language altogether, because simply if it said on sites, I don't think it would actually make sense. But that's a drafting point. I don't think it's particularly helpful to you to repeat all of the discussion we had this morning about the importance of settlement boundaries. We certainly would not be in favour of an approach which allowed this development to take place outside of settlement boundaries. But I think that's probably as much as we would wish to say.
Yes, I mean, obviously, I can bear in mind what we discussed this morning in terms of adjacent to the boundary and bear that in mind here. Mr. Stringer, you've got you want to come in?
Yeah, sorry, Madam Chair. I wasn't going to speak on this, but I've suddenly worked out that me and my parents have self-built 7 homes during our lifetimes, and I live in a row of 28 houses where 13 of them are self-builds. That includes 3 in that street that are in my family. That we are beginning to see in recent times. I fully support this policy, and I'll explain why. Because this is a move away from what we've done to date. Self-build classically has been the aspiration only of the self-builder, and I'll explain that. There are 2 houses being self-built at the moment in this road. And they will house, between the 2 dwellings, they will house 5 people, but there'll be 1,000 square metres of floor area in the 2 houses, and they won't pay a penny of sill. So certainly in these rural areas, we've got an awful lot of self-build fatigue, and we are unconvinced that self-build is a good thing. And I think everyone in the industry is assuming that self-build good, developer built bad, almost, and that's not true. There is a huge variety of self-builders out there, but the majority of self-builders we get, certainly over the last few years, have been extraordinarily large, and in locations not inside settlement boundaries, because they've taken advantage of the lack of 5-year land supply. So actually making self-build more smaller dwellings within places that you would normally have a planned approach in, I would suggest is a welcome move. But I do but I also, I don't know if it's for this plan, but I'm quizzical about how the 20 houses built by a developer needs to pay a sill payment for infrastructure that 20 houses built by self-builders don't create the need for. It's a moot point, but I don't get why self-builders don't pay a penny for doctors and schools and all the other stuff we do with sill that developers have to pay. Thank you, Chair.
Thank you, but I hear your point, but that's not something I have to consider at this point in addressing this plan in terms of the sill, why self-builders don't have to pay sill. But I understand what you were saying. Mr. Short, you want to say something?
Yes, please. It's in relation to the request you've made of the council to provide a statistical analysis as to its performance over the last, I don't know how many years, but against the current need of 105 dwellings per annum. I noticed that Mr. Hobbs made reference to the self-build still exemption claims. Based upon some work I did recently, it's quite interesting to note that quite a lot of those, at least in an adjacent authority, were being chalked up under the self-build category because they were rural building conversions. I wonder that if in the analysis of the statistics, the council is able to say how many of those are from conversions of such buildings rather than new self-build on new, not previously developed plots. Because from earlier conversations, of course, we know that the council's position on the use of such buildings outside settlement boundaries is no longer going to be supported. So there will be, if a barn conversion or a building conversion in the countryside is counted as self-build, then the council's stance on that particular policy is going to mean a reduction in the performance to the delivery of the self-build plot numbers.
Do council want to come back on that point for Mr. Short at all?
Well, it's been said, and yeah, I'll have a look at that when we do our figures.
Right, thank you. Is there anything else people want to say on LP11? I haven't got any more questions. Yes, Lady Hart.
Going back to the consistency point, that this requires less of a self-builder than some of the requirements on people who want to put a replacement dwelling under the other policies or an extension. So I think there should be a well-designed requirement. We've got into a definition of the historic environment. That's not used elsewhere. It's heritage assets that were used elsewhere. And it says the proposal should not cause significant harm to residential amenity. Elsewhere in the earlier policies, it's material or unacceptable or significant harm. So there's a variation again, and there's no felling of trees requirement here. And I think it ought to be consistent across these various categories of local housing policies. And also in 4, it's expected again rather than the required, and I don't see why there should be a lesser standard imposed on a self-builder. Sorry, expected to minimise dependence on fossil fuels rather than elsewhere it says required to minimise dependence. And given the council's declared a climate emergency, it seems to me it should be required, not expected.
Thank you. Obviously, the council have said they're going to look at the kind of consistency in that wording, so I'm sure they will look at this policy as well whilst they're doing that.
Thank you.
Is there anything else anyone wants to say? Lady Hart, your hand's still up, is that? That's, yeah. Thank you. Right, well, I think that then concludes everything we need to discuss today. I think it might be helpful if I could just run through with the council what we've agreed in terms of modifications or work they're going to do before you know, I'll run that through with them. If you want to stay and listen to that discussion, that you can do, but I just want to make sure that they and I have both got the same list of what's going on. But other than that, thank you all for your contributions. I may see some of you again tomorrow, and others I may not see again, but thank you all very much for your contributions today. It's been very helpful. But I say, if the council can stay on so I can just discuss what's going on in terms of changes.
Thank you, Madam.
Thank you. Right, I just adapt my list to what we've just agreed in that last session. 1H. Right, I think it just helpful if we can just I just want to check that you've got the same list as I've got. So I've got that you'll look through the entire plan in terms of MPPF paragraph numbers and just tweak those to reflect the new MPPF. In terms of LPO1, that you were going to look at the wording in relation to hamlets, and also I think there was that word applied that had come out at the end, and whether that needs to be in or not. But if it's not, at least in the suggested text, it needs to be crossed out. And whether it's defined hamlets and how you want to define those hamlets, and whether we have a footnote to explain it's the ones in table 2 and 3. We're going to look at paragraph 1303 to reflect the changes in LPO1 that have been suggested, because I think that refers to dwelling clusters or clusters as well, and obviously that's been suggested to take out. Check the wording. Oh yes, I've got that. Well, that's of the main modification suggested to LP1 to make sure it accords with what's written in the plan. That's got that down twice. You are going to look at some of the differences in wording between policies LPO1, LPO2, the various ones, just to get consistency in the wording between the different policies. The thing that that Lady Hart has just picked up in LP11 as well. Just going to look at some of those. And in LPO3 and other policies across the plan, you're going to check the wording for the criteria-based policies to ensure consistency, and just sometimes you put clearly say that you apply to all the criteria, and other times you don't. So just to get consistency in how you phrase that so that people are clear. In terms of the supporting text to LPO 6 and 7, you need to look at just the issue. I mentioned footnote 26, 27. I think there's a I think at one point it says footnote 27, and I think it should be 26. And also just some of the wording in paragraphs 13, 29, 30 and 31, which I think there's some missing words, so it just needs it's mainly that's just typos and things that need to be looked at, just so those paragraphs make complete sense. LPO 6, you're going to provide me with further evidence to show the justification for the 50% figure. And you said that's going to come in like 2 different parts. LPO 6C, consider wording to clarify the kind of document into, we were the discussion we had about it being the most relevant district needs assessment supported by the council. You were just going to look at that and consider the kind of wording and what was needed for that. Look at the overlap between LPO 6C and LPO 7.3, where the right place for that is, and whether that should LPO 7.3 should be in with LPO 6C. Also in LPO 6C, you are going to provide me with evidence of whether you've got a history of bungalows being changed into houses. in LPO 7, what provide me with evidence of what the market has provided in recent years in terms of specialist and special needs housing. And then in LPO 7, 1B, you're going to possibly look at whether Ipswich Fringe and the hinterland villages in the Ipswich Fringe should be added in to that. LPO 7 1H, look at M402 and whether that was appropriate, or would it make sure it just doesn't rule out any kind of special needs housing that needs to be provided. And then finally, I think LP 11, you were just going to provide me with a list of what's been provided in recent years in terms of the self-build housing. Was there anything, have you got anything else that I've missed off?
It was just that point at the end about, and whether it's a conversion or whether it's a new build as well.
Right, yes, yeah.
Self-build, yeah. Okay.
But other than that, is that's there's nothing else I've missed off. Right, well, thank you very much.
Yeah, I don't think so. Thank you. Yeah. Okay.
I think we did say we'd look at the words in LP 11 about appropriate sites.
Oh, right, yeah. Right, well, thank you very much, and I'll probably see you both tomorrow.
Okay, thank you.
Okay.